Yes.
Adjournment request, if any, from item number 1 to 4.
With the concern of the petitioner,
Louder.
with the concern of the petitioner, I beg to mention item number 4 and 5, my lord. But it will be taken up after 3 weeks, lord.
4 and 5
4 and 5, my lord.
as jointly prayed for. To re-notify on after 3 weeks.
9th of September.
My praise the Lord, my lord. Item number 3, my lord. So she was kind enough to grant me 10 days time to obtain instruction from my client. But I have received some information that he is under treatment in Hyderabad. I couldn't contact him. So I need some more time.
Is Mr. At the request of Mr. A.K. Purkast, learned senior advocate, the matter is adjourned to after 3 weeks.
But
Fix the date properly, not all cases.
4th of September.
my
From item number 6 to 18, adjournment request.
Please, my lords, I beg to mention item number 11, my lord.
11.
My lord, may kindly adjourn the matter
Oh,
for
that's,
one.
you have already circulated the adjournment slip. As jointly prayed for, notify, so and so date.
May it please your lordship, I beg to mention item number 7 and 8 with the consent of the other side.
Yes,
May adjourn the matter for the day, your lordship, pass over for the
for
day.
the day.
Yes, your lordship. Pass
So
over
this
for the-
goes, this is a hearing day. Therefore, if it is adjourned for today, it goes on next hearing day.
Yes, your lordship, that will be.
As prayed for, re-notify next hearing day. But next week. All right, yes,
May I please, your lordship, I beg to
12.
mention item number 12.
yes,
Let me be
adjournment slip as prayed for. 2 weeks.
2 weeks.
19. From item number 19 to 24, adjournment request.
May it please your lordship, I beg to mention item number 19 with the
Yes.
consent of the other side. Lordship, some personal difficulty,
Item number 19.
lordship.
All right, as prayed for, as jointly prayed for. On behalf of the parties, re-notify. 2 weeks.
2 weeks. Lordships,
28-8.
much obliged, lordship.
Yes.
Any other request?
Lordship, may it please your lordship, I would beg to mention a listing matter.
I will, if I don't hear you, I can't pass any order. You need to be audible.
I would beg to mention a listing matter of a writ appeal on 12th August 2025, next Tuesday.
What is the matter?
It's a tender matter and I was
It's a what matter?
tender matter.
Tender.
Yes,
Yes, and you have filed it when?
yes, lordship. And I was
Is it an appeal or writ petition?
appeal.
Writ appeal.
Yes,
When did you file it?
I filed it.
Is it against disqualification?
Yes, lordship. The single just disqualified.
No, second judge would not have disqualified, would have sustained the disqualification. All right, when do you want it?
12th August. Next
12th of
Tuesday.
August. No, we can't give you 12th of August, somewhere after 15. After 15,
Okay, thank you, lordship.
all right.
Daily list for admission, item 1.
May it please your lordship.
Item number 35. Yes,
Yes, Lord. The appellant before your lordship is a joint venture consortium comprising of 3
you are
partners.
appearing privately for the appellant.
It's a private, government of Assam is not involved. Coal India is the
All
main
right,
opponent
all
party.
right,
Lord.
yes.
So it is regarding a tender relating to the carriage of coal from a colliery in Margherita to some other places of the country, lordship.
Yes,
And tender was issued on 7th of 5th of July 2024. I was one of the participants out of 12,
yes.
and I was found to be non-responsive on 2 counts, which I challenged before the learned single judge, and the learned single judge found that it was a valid disqualification.
Right.
So the two main core issue which on the basis of which I was disqualified or considered to be non-responsive,
Yes.
that I did not submit the local content certificate
Hmm.
in the name of the joint venture,
Yes.
which I have submitted in the name of two of the partners who fulfill the requirement.
And your joint venture is of how many partners?
Three partners, Joy Ambe, then JP.
That's all right. Names
three
we may
parties.
not remember, three
No.
partners.
Three partners.
And you provided the local content of two of them.
Two of them,
Hmm.
but they wanted that it should be in the name of the joint
JV.
venture, which I could not give at the right time.
Hmm.
And I'll place the law on that also. It
Yes.
is not actually required.
Hmm.
And the other one is that I have submitted a consortium agreement
Hmm.
with certain slight deviations from the format given by them
Consortium agreement between the partners.
between the partners.
And what was the requirement?
The requirement was that all three should be jointly and severally responsible for any default
All right. So let's
at
see.
the time of the tendering process and after if they are successful.
Let us, before we go to law, let
Lord.
us first see the condition.
Yes, Lordship, I'll
The-
place that
the
condition.
requirements.
Yes, Lordship. If Lordship is pleased to take volume 1,
Yes.
the terms and conditions Lordship will find at page number 140.
114.
140, Lordship. So here, clause number 2, eligible bidders.
Just a minute. These are additional terms and conditions.
Yes, Lordship.
These are instruction to the bidders.
Absolutely,
Where
Lordship.
is the NIT? It starts from which place?
It
Which
starts
page?
from 131.
Starts from 131. Yes.
So the contract word is a removal of HEMM for removal of overburden, so and so extraction and transportation of coal
Hmm.
from Tirap Colliery for a period of 10 years period.
Hmm.
And here, if Lordship is pleased to look at next page, page 132, scope of work and bill of quantity. Tenders are invited online on the website so and so from eligible bidders. The registration should be in the name of bidders for individual proprietorship firm, partnership firm, company registered under so and so, whereas a participation of joint venture consortium through GEM portal, the registration of bidders should be in the name of lead partner of the joint venture consortium and submitted documents against eligibility criteria should be in the name of the joint venture consortium. This is what the other side will refer to, that it should be in the name of joint venture consortium. Now coming to the additional terms and conditions at page 140, eligible bidders.
Yes.
2.2 is the relevant clause. Joint venture JV consortium.
Yes.
2 or more companies, contractors may jointly undertake contract. Each entity will be jointly and severally responsible for the completing the task as per the contract. These are the percentages. Lead partner should have 50%, member minimum 20, the other member also minimum 20. And joint venture must comply with the following requirements. I am coming to Roman 2. The qualifying criteria parameters, experience, financial resources of relevant period and the equipment's fleet strength of the individual member of the JV consortium will be added together. Lordship will kindly mark this, added together. And the total criteria should not be less than as spelled out in the qualifying eligibility criteria as specified in additional terms and conditions with document. However, the required working capital should be made by individual members of joint venture consortium as spelled out in the relevant clauses. Roman 3, the formation of JV consortium or change in the JV consortium character members after submission of the bid is not permitted. 4, the bid in case of successful bidder, the agreement shall be signed as to legally bind all members jointly and severally, and any bid shall be submitted with a copy of the JV consortium agreement providing the joint and several liabilities with respect of the contract.
Yes.
So if I get the work also, then also I have to execute an identical contract consortium agreement. Now, Lordship will kindly come to next page. 3-4 clauses are relevant, which I am placing. The bid submission must include documentary evidence to the relationship between JV consortium members in the form of JV consortium agreement to legally bind all partners jointly and severally for the proposed agreement which should set out the principles of constitution, operation, responsibilities regarding work and financial arrangements,
Yes.
participation, percentage share in total, that is also relevant, percentage share in total, and liabilities joint and several in respect of each and all the firms in the JV consortium. Such JV consortium agreement must evidence the commitment of the parties to the bid for the facilities applied for if pre-qualified, and execute the contract of the facilities if the bid is successful.
That's right.
Now, lead partners, those points are there, 7, 8. I'm coming to 12.
Hmm.
The JV consortium agreement must specify the share of each individual. For the purpose of execution of this contract, this is required only for the sole purpose of apportioning the value of the contract so that extent of individual members for subsequent submission in other bids if he intends to do so for the purpose of qualification of the bid. Then, Lordship, these are the main relevant provisions regarding the thing. And now coming to page 144, work experience. C. I'm coming to the last portion. Data to be furnished by bidders in bid submission confirmation sheet. Roman 7, the last one in that page. In case of bidder is a joint venture consortium, the work experience of any 1, 2, or 3 of the individual members of JV consortium or the JV consortium itself may be furnished as the work experience of the bidder.
Yes.
So the two options are given, either individually they can give or in the name of JV. So in our case, we have submitted in individual name.
Yes.
Now coming to page 146. At top, the work experience certificate issued by employer, principal employer should be contain the following important parameters. I'm coming to note, the note portion at the middle. B. In case of joint venture consortium, above documents of partners shall be furnished and work experience shall be made collectively by all the partners / members.
Yes.
Now coming to page 149. Supporting documents. Here, all the documents, all the conditions says that individually it can be submitted. I'm coming to the note portion at the bottom part of that page. In case the work service is awarded to a joint venture consortium participating in the tender, they have to submit PAN, GST registration as applicable in the tender and for the bidder status in the name of joint venture after award of work service in the name at the time of execution of agreement before the payment of first running on account bill.
Yes.
So if they are successful in getting the work, then only they have to give all this in the name of the JV. Next page, H. Legal status of the bidder. The bidder should be individual proprietorship firm, partnership firm, company registered under Companies Act / joint venture
Consortium.
and consortium. So the legal status of bidder, this bidder word, the learned single judge has given a lot of emphasis and therefore said that everything should be in the name of JV. Now, coming to page 152. This is regarding the joint venture's name. Now I'm coming to the other part, that is the local certificate.
Yes.
So local certificate, Lordship will kindly come to page 152, the last in terms of the above said policy, purchase reference shall be given by class 1 local supplier. In case of class 1 local supplier, class 1 local supplier means a supplier of service provider whose goods, services, works offered for procurement has local content equal to that of 50% as defined under the said order. Then class 2 and local contents, all these criteria are laid down here. Now Lordship will kindly come to 3.3. If the bidder is a subsidiary of a company, the experience and resources of the holding company or its other subsidiaries will not be taken into account. However, if the bidder is a holding company, the experience and resources of its wholly owned subsidiary will be taken into consideration. Now coming to note, the documents to be furnished by the bidder to prove that he is satisfying the eligibility criteria laid down should be in all the bidders in the bidder's name, except in cases those name has changed, owners continue to remain in the same, and in cases amalgamation of entities, and when a holding company relies on the credentials of wholly owned subsidiaries. Now, up till here, it is relating to the other issues. That is not covering me. Now, my issue comes here. Please refer to clause 2 of additional terms and conditions, ATCs of GM bid document. So I will cover by this part. And if we look at
Where is that?
clause 2, we have come to page 140, which I have already placed. That individuals, they have to be calculated together to fulfill the requirement of eligibility. In 2.2 says, if lordship is in place 140, once
Yes.
more, the qualifying criteria parameters, that is experience, financial resources of the relevant period, and the equipment's fleet strength of the individual members of the JV consortium will be added together. So everybody has to give individually and it will be added together if it is not in the name of joint venture. And the total criteria should not be less than as spelled out in the qualifying eligibility criteria as specified in additional terms and conditions. Bid documents, however, the required working capital shall be made by individual members of JV and spelled out in the relevant clause.
You read that.
Yes, Lord. So I'm not going back again. Here there's a reference of clause. That's why I went back for a moment. 153. Now, 19, clause 19, page 159. Evaluation of tenders. Here, in part 2 system, lordship will kindly come to B. There is a scope of, if there is a shortfall, there is a scope of giving additional documents also. But my case is not that. May I read it, lordship?
Yes.
In case the tender committee finds that there is some deficiency in uploaded documents corresponding to the information furnished in bid submission confirmation sheet, or in case corresponding documents have not been uploaded by bidder, then the same will be specified online by evaluator, clearly indicating that the omission, shortcomings in the uploaded documents, and allowing 7 days, 7 into 24 time online resubmission by bidders. Additionally, information shall be sent by system-generated email. Lordship will kindly mark this, system-generated emails and SMS. But it will be the bidder's responsibility to check the updated status information of GEM portal regularly after opening of the bid. No separate communication will be required in this regard. Non-receipt of email and SMS will not be accepted as a reason of non-submission of documents within prescribed time. The bidder will upload the scanned copy of all those specified documents in support of the information declaration furnished by them in bid submission confirmation sheet within the specified period of 7 days. No further clarification shall be sought from bidder. The shortfall information documents should be sought only in case of historical documents. Lordship will kindly mark this word, historical documents. This is one area where the learned single judge relied upon. In case of historical which pre-existed at the time of tender opening and which have not undergone any change then. These should be called only on basis of recommendation of the technical committee. So far as the submission of documents is concerned with regard to the qualification criteria, after submission of the tender, can only related shortfall documents should be asked for and considered. For example, if the bidder has submitted a work order document relating to a particular contract without its completion performance certificate, the certificate can be asked for and considered. However, no work order of new contracts should be asked for so as to qualify the bidder.
Yes.
Now, E. In case bidder submits requisite documents online as per bid document, then the bidder shall be considered eligible for opening of the price bid. H. In case bidder fails to confirm the submitted information declaration by the submitted documents as B above, there his bid shall be rejected. However, if the confirmatory documents do not change eligibility status of the bidder in connection with his submitted information, then his bid, their bid will be accepted for opening of price bid. 162, Lordship will come. Procurement and preference regarding Make in India. Lordship, that is not very relevant. Lordship will kindly come to page 163.
Yes.
Roman 2. at the center. In the procurement of work which are not divisible and in procurement of services where the bid is evaluated on price alone, the following criteria shall be followed. Roman 3. In case such lowest eligible class 1 local supplier fails to match the L1 price, the class 1 local supplier with the next higher bidder then with the margin of purchase preference shall be invited to match the L1 price, and so as the contract shall be awarded accordingly. In case none of the class 1 local suppliers within the margin of purchase preference matches the L1 price, then the contract may be awarded in the L1. This point was not considered. In case any argument comes from that, then I will explain this, what exactly it is meant. Now, Lordship will kindly come to page 168. This is very important because my case can be considered under clause 22. Examination of bids and determination of responsiveness.
Yes.
22.1. A substantially responsive bid is one which conforms to all the terms, conditions, and specifications of the bidding document without material deviation or reservation. My case is that there is no material deviation in my case, and material deviation is explained here. A material deviation or reservation is one, A, which affects in any substantial way the scope, quality, and performance of the work. I do not fall into this. Which limits its substantial way, which limits in any substantial way, inconsistent with the bidding documents, the employer's right of or the bidder's obligations under the contract. I do not fall into this category also. C, whose rectification would affect unfairly the competitive position of other bidders presently substantially responsive bids. So not an issue in my case. So there is no case of, in my case, regarding material deviation as per clause 22. So some deviation is permitted, but it should not result in material deviation. So when the facts will be complete, then this argument will come, Lordship. Now, after my submission, they have sent me this for clarification. The last date was 5th of August last year. And on 16th, I received this. Page 278. There are 3 requests from their side, the technical committee. Down below, request number 1. Undertaking clarification description. You are requested to submit the certificate in the name of JRVPL, the JWP and DMC issued by practicing costs accountant, practicing chartered accountant regarding the local content as per Annexure Roman 9A of ATC bid document. So their first request is that I have to submit a certificate in the name of JV instead of I have submitted in the name of 2 individuals, which fulfill the criteria. So this is number 1. Number 2, you are requested to submit a clearly readable copy of the partnership deed of the Dev Mining Company, one of the constituents.
Where is the other request? First clarification, first one.
I am request 2 and request 3.
Request 3.
Now request 3 is most very interesting, Lordship. In this case, I failed. There is no, clarification description, Lordship will see. Due to text limit by the GEM portal, the query is attached. My case is that attachment did not come to me at any point of time, which they have also not denied till now in any of the affidavits. The attachment, what they wanted, my affidavit which I have submitted, it has 17 paragraphs instead of 15 paragraphs in the format. And I added 7 more words in the format. That clarification they sought. There is no shortfall of document. There, I was not failing in my duty to submit all the materials. I submitted. So they have some queries in their mind. So they sought, now it has come to know our knowledge after my rejection that they sought clarification regarding this consortium agreement. Whether it will be
And
all the
you were not aware of it because the attachment never got.
they never got. And the learned single just said that I submitted an application on 23rd where I did not raise this issue, but I have stated very clearly that if you need any clarification, because on 22nd I came to know when I was rejected. I came to this was of 15. The query was of 15. The rejection was of 22nd. And on 23rd, I submitted a representation where I have very categorically stated that if you need any clarification regarding my consortium agreement, I'm going to clarify. But clarify does not mean that there is shortfall. That means that thing will remain intact. If Lordship passes a judgment and there is some confusion of the parties, then we can always come for clarification. That will not change the tenor of the judgment. The judgment will remain intact. I fail to understand, they fail to understand the language of my affidavit. This agreement. So this attachment, none of their affidavit said that it was not there. It was there. So this was of 15. On 17, I submitted this certificate. Lordship will kindly come to the next page. Now it is this certificate of local content. I fulfill the local content that 50% or 100, whatever is the limit, I fulfilled. Now it is in the name of consortium at JVPL so-and-so, so-and-so. And this is dated 17th August. On 16th, they sought that document. I submitted because I cannot make a backdated document.
That's it.
The other documents, Lordship will kindly come to page 280, next page. The first document I submitted of 2nd of June, and the third one is on page 282 of 12th of July. The last date was the 5th of August. So these two I have submitted in the name of two of the partners of the JV, and they wanted it in the name of the JV. So on 16th, they wanted that certificate. I submitted on 17th. So this is one ground that this is not a historical document. The learned single just held that this 17/8/2024 is not a historical document in the name of the JP. So that is on one ground why I was found to be.
Let's see the technical evaluation committees.
I'll come to that, Lordship. Only 282, 286. The rejection, that is of 22nd of August last year. The two grounds why I was disqualified. Now, may I read it, Lordship, the
Yes.
comment for?
Yes.
As the documents of local content submitted against the clarification is dated 17/8/2024, which is after the bid submission of the date that is 5th August 2024. That is ground number 1. And the submitted documents regarding consortium agreement is not in the line of format provided in Annexure 2 of the ATC of bid document. Therefore, you are not fulfilling the eligibility criteria as per the requirement of the bid document. The second part is that my consortium agreement is not in verbatim with the format which they have given or the pro forma which they have given. But they have issued lot of instructions how the agreement has to be prepared, which I have placed it under clause 2. So now Lordship will kindly come. Now, Lordship will only for my satisfaction, this technical issue, page 283. In the portal, my serial number is 3. So my firm's name is there. Then Lordship will see the status disqualified specification view. When I click the view, then this page 286 comes, it pops up. In the case of that query, there was no view. If Lordship is pleased to come to page 278, there they said in the query, in the request number 3, due to text limit by the GEM portal, the query is attached. So there is no column of view. There was no view. There was no uploading of that. But and what they wanted, that they wanted, Lordship, I will show it, the minutes. Second one there. Second one.
Can I take the liberty of coming back in 5 minutes?
Yes.
Here, Lordship will see their minutes where they have. page 574, if Lordship is pleased to take the second volume number 2.
Yes, page.
Page 574. It starts from 568, annexure 2, minutes of tender committee. 568. At the top, Lordship, you see subject, minutes of the tender committee held on 14/8. Now coming to page 574. Public procurement preference to make in India for the local suppliers, that is local content certificate. The right hand side, bidder not submitted a certificate in the name of JARPL, JPW and DMC issued by the practicing cost accountant, chartered accountant regarding local content as per annexure Roman 9A of ATC. So this is one. And the other one is at page 577, clause 3. From top, bidder at serial number, that is consortium agreement, that is lead partner stated that all the partners of the consortium shall be jointly and severally liable during the bidding process and for execution of the contract as per contract terms with the employer. And at serial number 4.3 of 6, that is participation, share and work responsibilities, stated that however, all the parties shall remain jointly and severally responsible for the satisfactory execution of the project in accordance with the contract terms and conditions. But at serial number 7, joint and several liability stated that all partners of the consortium shall be liable jointly and severally to, as mentioned, proportionate clause number 4. In clause number 4, we said 50, 30, 20. So this is what we have said. And in their clauses also.
They say it has to be 50, 20, 20.
50, 20, 20. We have done it. We have mentioned, but this additional word to be as proportionate in clause 4. That additional thing, because at top we have to give the shares also. That is requirement under clause 2, Roman 12. We inserted that. And in the final column, we said, as per that share. That will not take away anything from them. And that will not change the tenor of the whole agreement. The objective is that they should be protected.
Perfect.
Now, therefore, what they said, Lordship, the next line, a clarification is required whether the statement written in serial number 7 for liable jointly and severally is in line of the statement written at serial number 4 and serial number 4.3 of 6 of consortium agreement submitted by bidder or liable to be proportionate share. That is JPW 50%, Jayambe 30% and Dev Mining 20%. So this is what clarification they wanted. It was not known to, otherwise I cannot shark away from that responsibility of showing it. There is no reason. They are not asking something from the moon. They want a clarification and there is no shortfall in that according to them itself. There is no shortfall of that document. The only thing is that the clauses.
Yes.
So they may be not legally attuned with these wordings. Therefore, they want a clarification. And on top of that, if I am successful, I have to execute a fresh consortium agreement.
Oh, that's after you are found to be.
If I get it.
The work order is-
Yes, Lordship. So now these are the two clauses. Now my first argument will be that. Okay, sir. Yes, one more thing, Lordship, that representation 288 in the first volume. That will complete my facts. So on 22nd, I received the information that my tender was considered non-responsive and I was rejected. On 23rd, I wrote this representation to them at page 288 and page 289, 4 paragraphs from below. Furthermore, regarding the consortium agreement, have Lordship got it?
Yes, yes.
Our submission did meet the format specified in Annexure 2 of the ATC bid document. We are willing to provide additional information or clarify any points that may be unclear. In the light of this point, we would like to request for reconsideration of our eligibility based on the following. So we have indicated, once we came to know, there is no reason, Lordship,
That's
that
right. So was this responded to? No,
I think they have responded in their official.
no. Was this responded to by the ATC?
The Coal India.
I mean, the Coal India is all right. Was this letter?
Yes.
This agreement towards disqualification of the bid submitted? You gave an explanation.
We
So
did not
this-
explain it. We submitted a representation for reconsideration of our.
Situation. So
But-
what happened? Was this request considered?
No, it was not considered.
And did you get any information whether?
No,
it was-
but during the proceedings, they said that they have rejected it at 306. 306. Yes. Representation initiated 23rd. Dear sir, we hereby write this to submit the disagreement towards a disqualification. The submitted consortium response description, the submitted consortium agreement is not in line of so and so. And weak documents submitted by the bidder through challenge rejection window shall not be considered other than the application uploaded as appeal. So they said that we have to file appeal.
Appeal before whom?
Appeal before there is a appellate authority within their system, Lordship. The departmental thing, Lordship. So now let us go through these certificates. That I have submitted 2 documents regarding the local content. The first content is local content. According to them, it should be in the name of JV. And my contention is that
That's not required.
that is not required. Their whole terms and condition and additional instructions very categorically said that individually it can be given, but they will do the calculation, the totaling they will do. So arithmetic part they will do, and if it fulfills the basic quantity criteria, then I am true. And that is the law, New Horizon, that Supreme Court case also. In case of JV, individual credentials has to be calculated. So that is a settled position of law. So I am true in that point, Lordship.
Yes.
Now coming to the other, that what is this affidavit? Whether I have not fulfilled any of the basic requirements under that particular consortium agreement, whether from the document which I have submitted, whether they are not protected in case of any default on my part. Page 124. What is their document and my document? I can give a comparison. I have prepared a comparison, Lordship. Very minor, Lordship. In fact, I have added 7 more words and the paragraphs are. Page 1. আমার phone 187 pro forma. And ours is 120. 124 is our consortium agreement. That was good. Okay. So here, Lordship, the lead partner at page 126. May I read it, Lordship?
Yes.
JPW Infratech Private Limited shall be the lead partner of the consortium and is in charge of performing the contract management. JPW Infratech Private Limited shall be attorney of the parties duly authorized to incur liabilities and receive instructions on or for and on behalf of any or all of the partners of the consortium, and also all the partners of the consortium shall be jointly and severally liable during the bidding process and for execution of the contract as per contract terms with the employer. So I have specifically stated that I am fully covered. Full responsibility I have taken. All consortium partner JMB, JPW and Dev Minings nominate and authorize Sri Joy Prakash Washan, Director JPW, to sign all deeds, etc. and for and on behalf of the consortium. So lead partner I have fulfilled. Now coming to 6, page 127. Participation, share and work responsibility, which they have asked for in their instruction. The parties agree that their respective participation share, hereinafter called participation share in the consortium, shall be as follows: JPW 50%, JMB 30%, Dev Mining 20%. 4.2, the parties shall share the rights and obligations, risks, costs, expenses, working capital, profit or losses or other arising out of it and in relation to the execution of the project individually or collectively. 4.3, the parties shall jointly execute the work.
So it is almost in line, no?
Almost.
I mean, not even almost, it's exactly in line.
The seven they found, the learned singular found that there are 7 more words. All partners as consortium shall liable jointly and severally to as mentioned in proportionate clause in 4.
Already
That
we've seen that.
to the as mentioned in proportionate clause 4. This is what we have added. Even without adding also, the meaning is same.
7.
During the pre-qualification and bidding process and event of contract is awarded during the execution of the contract in accordance with the contract terms. So what we have added to the as mentioned in proportionate share in clause number 4. This is what we have added. It is more clarity we have brought. We are not shirking off any of the responsibilities.
How is the judge, single judge dealt with it?
Yes, Lordship, that Lordship will find at page. Yes,
Paragraph. tell me
yes,
the
paragraph, Lordship, I am coming. Paragraph 46. Yes, paragraph 46 will be page 752.
Yes,
May I read it, Lordship?
yes, yes.
A perusal of the documents and the submissions made by the council for the parties show that the technical bid of the petitioners had been rejected on the ground that the local content Make in India certificate has not been issued in the name of the bidder JV Consortium, which was the requirement of the notes in clause 3.3 of the ATC. 3.3, if the bidder is a subsidiary of a company, the experience and resources of the holding company or its subsidiaries will not be taken into account. However, if the bidder is a holding company, the experience and resources of its wholly owned subsidiary will be taken into account. This is not relevant to us. Note, the document to be furnished by the bidder to prove that he is satisfying the eligibility criteria laid down should be in all the bidder's name, except in cases where, though the name has changed, owners continue to remain the same, and in case of amalgamation of entities and when a holding company relies on the credentials of its wholly owned subsidiaries, please refer to clause 2 of the additional terms and conditions of the GEM bid document. Clause 2 also I have placed, Lord. The clarification certificate dated 17/8/2024 submitted by the petitioner in terms of clause 19(2) Roman 2B in response of the request number 1 could not be accepted as the shortfall information document should have been existing at the time of opening of the tender and which should not have undergone change since then. Clause 19(2) Roman 2B further clarified that only the related shortfall document were to be asked for and considered. The second ground for rejecting the petitioner's technical bid was that the JV consortium agreement submitted on behalf of the petitioner was not in consonance with the format provided in Annexure 2 of the ATC bid document. Now coming to paragraph 52. The finding, final. In view of the reasons stated above, it is clear that the local content certificate had 755 down below, Lordship.
Yes.
In view of the reasons stated above, it is clear that the local content Make in India certificate had to be submitted in the name of petitioner, that is JV consortium bidder. This is the finding, Lordship, which had not been done. So it should have been in the name of the JV. This is the finding of the learned single judge in my humble submission. The clarification sought by the state respondent under request 1 was answered to by the petitioner by submitting a document on 17/8/2024, which was not a historical document. As required under clause 19.2, etc. The fact that the state respondents have interpreted clause 19 to be essential condition of the tender and the clauses appear to be an essential condition where the court does not find any infirmity in the rejection of the petitioner's technical bid on this count. So this is the finding. So that is totally against the law and is in conflict with the law laid down in New Horizons case, as well as the clauses given in the additional terms and conditions of the tender, the instructions. There itself in several times, it has been repeated that it should be individual name in case of JV. So now this is 1 point, Lordship.
Yes.
And one top of one very important that this JV was constituted just 1 month prior for participating in this tender, and which is permitted. So they have not executed any work in the name of JV till now. But we have done a mistake. What mistake we have done? We should not have submitted this 17.8. Because it is not in the name of JV. What the chartered accountant has done, he has calculated the two persons' quantum and credentials and gave it in the name of JV, which in my humble submission may not be the correct procedure. But still, Lordship, they have rejected it because it is dated 17. If we had given a date of 4th of August, then it would have been accepted.
Who appears for respondent number 6?
Yes, I appeared.
Mahalakshmi infra contract. You have been given the word
I've
contract.
been given the letter of acceptance,
No, agreement.
agreement of. But only thing, Milord, that adjournmental thing is not out there.
No, but this has to be answered. So Coal India.
Coal India, I have.
Yes.
Only one thing I'd like to, there is an interim order that this, whatever order they have issued, that will be subject to final outcome.
And I will divide my arguments into 2-3 different categories. First is, what are the requirements under the NIT?
Just before that, Mr. Saikia, Lordship, just show me that citation. New Horizon.
New Horizon, I have.
That may or may not be needed because of the terms and conditions, the instruction to the bidders, but nonetheless.
Yes, but still, this will fortify my case.
Yes, let's see.
May I place the paragraphs also?
Yes, yes.
Paragraph kita di. No, more paragraph kita dia. More for the bola kita ni kita. So 11 paragraph kita pun. No. Paragraph 17, 18, 19, may I read it also? New Horizon.
Yes.
1995 4 SCC, page 418. Paragraph 17, Lordship. May I read? In fact, this judgment has been relied by this honorable court in umpteen number of cases. May I read it, Lordship? At the outset, we may indicate that in the matter of entering into a contract, the state does not stand on the same footing as a private person who is free to enter into contract with any persons he likes. The state, in exercise of various functions, is governed by the mandate of Article 14 of the Constitution, which excludes arbitrariness in the state action and requires the state to act fairly and
These are
reasonably.
basic principles.
These are the
With
basic,
respect-
I'm coming, Lordship, I'm coming to the specific paragraph.
Witnessary principle.
In
joint
fact, I've
venture.
left my books. In the book, I have the specific paragraph. I'll just come, Lordship.
Come to page 24.
Yes, Lordship. The expression joint venture is more frequently used in the United States. It connotes a legal entity in the nature of partnership engaged in joint undertaking of a particular transaction for mutual profit, or an association of persons or companies jointly undertaking some commercial enterprises wherein in all contribute assets and share risk. It requires a community of interest in the performance of the subject matter, a right to direct and govern the policy in connection therewith, and duty which may be altered by agreements to share both in profit and losses. According to Wards, the permanent edition, a joint venture is an association of 2 or more persons to carry out a single business enterprise for profit. A joint venture can take form of a corporation wherein 2 or more persons or companies may join together. A joint venture corporation has been defined as a corporation which has joined with other individuals or corporations within the corporate framework.
That's right. So para 26, that's the law which you want to.
Once it is held that the NHL is a joint venture as claimed by it in the tender, the experience of its various constituents, namely TPI, LMI, so and so, had to be taken into consideration if the tender evaluation committee has adopted the approach of a prudent businessman. The conclusion would not be different if the matter is approached purely from the legal standpoint. It cannot be disputed that in law, a company is a legal entity distinct from its members. It is laid down in the House of Lords, etc. Lordship. কিতাপখন আনিব লাগে না? Paragraph.
Yes.
There are other judgments also in the same line of.
No, that's all right. That
Lord.
may not be relevant.
Lords.
What is relevant for this case is, what are the requirements in the NIT? What is it that the appellant as a bidder, joint venture bidder submitted? And how is it that the authorities undertook the decision-making process? To appreciate that, Marun, first, your lordship will just make a note of two facts. One is, your lordship will find in the NIT, this has a relevance, that's why I'm pointing it out. Page 131, the NIT starts. The value of the contract is 1561.88 lakhs, which is around 1,561 crores. And the last date of submission of the bids is 5/8/2024. These two facts have a relevance. I will indicate as we proceed. Now, if your lordship will kindly turn to page 132. At the very top, clause 1. Tenders are invited online on the website so-and-so from the eligible bidders. The registration should be in the name of the bidder for individual, proprietorship firm, partnership firm, company registered under Companies Act. Whereas for participation of joint venture or consortium through GM portal, the registration of the bidder should be in the name of the lead member of the joint venture consortium, and the submitted documents against eligibility criteria should be in the name of the joint venture consortium. At the very outset, it was made clear that although you can, the registration may be in the name of the lead member, the documents submitted for eligibility criteria, and this eligibility criteria is expressly provided for. I'll point out as we proceed. It has to be in the name of the joint venture bidder. Now, if your lordship will kindly turn to page 140. At page 140, clause 2, eligible bidders, who would be eligible bidders is provided. 2.1. The invitation for bid is open to all bidders, including an individual, proprietorship firm, partnership firm, company registered under Companies Act, or a joint venture consortium. The bidders shall be eligible to participate only if they fulfill the eligibility criteria specified in bid document, additional terms and conditions, etc. In a tender, a bidder shall participate in one bid only. Joint venture consortium, 2.2. 2 or 3 companies, contractors may jointly undertake contracts. Each entity will be jointly and severally responsible for completing the task as per the contract. Then subclause 4. Clause 2 was pointed out. This pertains to only experience, financial resources, etc. Clause 4. The bid, and in case of a successful bid, the agreement shall be signed so as to legally bind all members jointly and severally. And any bid shall be submitted with a copy of the JV consortium agreement, providing the joint and several liabilities with respect to the contract. Now, if your lordship kindly turns to subclause 6 in the next page. The bid submission must include documentary evidence to the relationship between JV consortium members in the form of JV consortium agreement to legally bind all partners jointly and severally for the proposed agreement, and it goes on. Then clause 12. Why is this percentage share is required is clarified. The JV consortium agreement may specify the share of each individual member for the purpose of execution of this contract. This is required only for the sole purpose of apportioning the value of the contract to that extent to individual members for subsequent submission in other bids if he intends to do so for the purpose of qualification in that bid. So
This is for something else.
for something else.
This is for the purposes that, see, there is a company, there is a company called X, which is part of the joint venture. and X has the particular experience and the experience and the share capital here. Now, if it individually applies for a bid,
Subsequent bid.
therefore this certification of JVE would not apply to him. It has to be separate.
Precise.
So this
So
has
it
got-
is for the, it is for the sole purpose.
That's all right. So this is.
It's for
not-
future contracts, basically.
It has got nothing to do with this contract.
No, what I was indicating to your lordship is this apportioning of shares. Here, let's say X, Y, and Z companies get together, form a joint venture. X has a share of 50%, Y has a share of 30%, Z has a share of 20%. Now, this apportionment will be relevant only for the purpose if either X or Y or Z decides to individually participate in a tender process later on. He will be entitled to, as a qualifying criteria, only to the extent of his share. That is the purpose. Now, this agreement of joint and several liability, there is a specific format given that your lordship will find at page 187. What is it to comply with this? What is the certificate that is, what is the agreement that is required to be submitted? This is part of the NIT. Page 187, it starts. The clause relevant is at page 189. Clause 5, joint and several liabilities. All partner of joint venture consortium shall be liable jointly and severally during the pre-qualification and bidding process, and in the event the contract is awarded, during the execution of the contract in accordance with the contract terms. So this is the unconditional.
No, but where was that missing?
I'll come to that. I'll come to. Now, they have to do one more thing. If your lordship will kindly come to page 142, come back to page 142. At the very threshold, the tender committee is required to do this one. As I proceed, I'll point out. The eligibility criteria is provided at 142. Clause 3, right in the middle. Eligibility criteria of the bidder. Eligibility criteria to qualify for award of the contract. A, bid submission confirmation sheet, BSC sheet. Bidders are required to submit the duly filled bid submission confirmation sheet in PDF format as per instruction provided in the GM bid document under section bid confirmation sheet for technical evaluations. The bid submission confirmation sheet provided by buyer in secured so-and-so format. The scanned copy of the documents will be verified against the data furnished in the bid submission confirmation sheet. So at the very threshold, once the technical bids are open, the tender committee is required to see the conformity with this BSC sheet. Now, the other requirement is, this is in furtherance, this whole tender is in furtherance of the Make in India policy of the country. Now, for that, clause 3 at 142 starts, your lordship will find that A, B, C, D, it goes on. Various eligibility criteria is laid down.
Yes.
Like, for example, if your lordship turns to 144, your lordship will find a clause C, which pertains exclusively to work experience. Right at page 144, somewhere in the middle. This clause C pertains exclusively to work experience. Then as we proceed, your lordship will find at page 146. At page 146, your lordship will find clause D pertains exclusively to working capital. And it goes on like that till we reach clause R at page 152. So, referring to other clauses has no relevance whatsoever because each subclauses A, B, C, D pertain to a different field altogether. Clause R exclusively pertains to the Make in India policy of the country. And how it is to be done is this. Documents are required to comply with the order number so-and-so for preference to Make in India as applicable issued by the Government of India as amended from time to time shall be submitted. In terms of the above said policy, purchase preference shall be given to class 1 local supplier. In terms with the above said policy, class 1 local suppliers and class 2 local suppliers shall be eligible to bid. So no other, if someone does not add local value, he will not be even eligible to participate. Now, what is a class 1 local supplier is defined. A class 1 local supplier means a supplier or service provider whose goods, services, or works offered for procurement has local content equal to or more than 50% as defined under the said order. Now, if your lordship kindly turns the page, what is local content is also defined as subclause D. Local content means the amount of value added in India.
Where are you reading?
Page 153, subclause D. Have my lord's call.
Yes.
Local content means the amount of value added in India, which shall be the total value of the item procured, excluding net domestic indirect taxes minus the value of imported content in the item, including all customs duties, as a proportion of the total value in percent. Now, for this also, there is a format provided that is referred to in right in the middle. There is another subclause B. That is why I pointed out the estimated value of the contract. If the estimated value of procurement is more than rupees 10 crores, which is the case in this case, all the bidders shall submit along with its bid a certificate with UDIN, Annexure 9, capital A, from the statutory auditor or cost auditor or of the company, in case of companies, or from a practicing cost accountant or practicing chartered accountant, in respect of suppliers other than companies, giving the percentage of local content. Now, this format your lordships will find at page 208. This format, since it is for various tenders, it is given for both contracts below 10% and contracts above 10%. So your lordship will find certificate of local content as per public procurement preference to Make in India order 2017, etc. IV, the statutory auditor, etc., of Messrs. So-and-so having registered office at so-and-so, hereby confirm that the percentage of local content in the offered product service of Messrs. So-and-so is so-and-so percent, and meets the local content requirement of class 1 local supplier as prescribed under public procurement, etc. Or if it is above 10 crores, the next one will apply. And right below that, your lordship will find within bracket, it is mentioned, delete whichever is not applicable. So in this case, when they submit the certificate, the first part is not required to be given. Then what follows is important. The details of location at which the local value addition is made are as under. So merely saying that I have added local content will not be enough. We should be able to verify. So how do we verify? Only when they specify that these are the places, X, Y, Z location, where the local content has been, value has been added in the country. We have imported 50%, remaining 50%, we have added value in ABC location. Now, coming to what, two more important clauses. There's another clause. There were 3 grounds on which initially a deficiency was found. One was this 19C, page 160. Page 160. So one of the conditions when my learned friend was placing the rejections, your lordships have noted that one of the things that was pointed out by the tender committee was that he had submitted an illegible copy of a partnership deed. So the requirement is this, 19C. It is responsibility of the bidders to upload legible, clearly readable, scanned copy of all the required documents in the bid document. Now, how will the evaluation take place? That your lordship will find at page 159. After, right in the middle, your lordship will find evaluation of tender. After opening of the tender technical bid, as the case may be, it will be evaluated by the constituted tender committee. Evaluation of tender, part 2 system. After opening of the technical bid, the documents submitted by the bidder in cover 1 as enlisted in the bid document will be downloaded by the evaluator and shall be put up to the tender committee. The tender committee will examine the uploaded documents against information declarations furnished by the bidder in bid submission confirmation sheet. So at the very threshold, at the very outset, as soon as the tender committee opens the technical bids, what is it is required to do is take out the BSc sheet which gives the data about what are the documents he has submitted. They are simply required to tally it with the sheet, whether those documents are actually submitted or not. Now, as we proceed, if it conforms to all the information declarations furnished by the bidder in bid submission confirmation sheet and does not change the eligibility status of the bidder, then the bidder will be considered eligible for opening of price bid. In case the tender committee finds that there is some deficiency in uploaded documents corresponding to the information furnished in bid submission confirmation sheet, or in case corresponding documents have not been uploaded by bidder, then the same will be specified online by evaluator, clearly indicating the omission shortcomings in the uploaded documents and allowing 7 days time for online resubmission by bidders. Additionally, information shall also be sent by system-generated email and SMS, but it will be the bidder's responsibility to check the updated status information on GM portal regularly after opening of bid. No separate communication will be required in this regard. Non-receipt of email and SMS will not be accepted as a reason for non-submission of documents within prescribed time. The bidder will upload the scanned copy of all those specified documents in support of the information declarations furnished by them in bid submission confirmation sheet within the specified period of 7 days. No further clarification shall be sought from the bidder. Now, next is very important. The shortfall document information documents should be sought only in case of historical documents, which pre-existed at the time of tender opening. That is why the date of opening 5/8 is relevant, and which have not undergone change since then. Very express. Whatever document clarification we seek, it has to be a pre-existing document prior to the date of the opening of the tender. That is why when he submits a document of 17/8, the tender committee records that it is not a historical document, it does not comply with it. Now, coming to what is it that the appellant submitted as a bidder. If your lordship will first take up page 124, that is the consortium agreement. I'm sorry, my lord, there is one more very important clause which I missed in the tender. If your lordship will kindly come to page 156.
Yes.
Right at the bottom, 15C. The bidders will have to accept unconditionally the additional terms and conditions, instructions to bidders, service level agreement, etc. So there cannot be any counter condition put by the bidders. Now, what is it that he submits? Page 124. This is the agreement, joint venture agreement that he submitted. And the problematic clause is at page 127. Now, if your lordship will kindly compare this with page 187, 189. This, firstly, the number itself is wrong. At page 127, it should have been serial number 5, paragraph number 5. So, which means they have added some further things. But the problem arose here. In 189, the format says very clear. All partners of joint venture consortium agreement shall be liable jointly and severally during the pre-qualification and bidding process, and in the event the contract is awarded, during the execution of the contract in accordance with the contract terms. Now, if your lordship comes back to page 127, what is it that he says? All partners of the consortium shall be liable jointly and severally to the as mentioned proportionate clause number 4. And if your lordship goes to the top of the page, although the main paragraph is marked as para 6, the sub-paragraphs are marked as 4.1, and there is a percentage. The first constituent 50%, second constituent 30%, third constituent 20%. So this is not a clear unconditional joint and several liability clause. It is a conditional clause, which is not permitted under the NIP. Now comes the local content certificate. If your lordship will again take up what is it that he
Controlling provision is jointly and severally liable. That's
but if they say that we are jointly and severally liable, partner A is liable only to the extent of 50%. Partner B is liable only to the extent of 30%. Partner C is liable only to the extent of 20%. It makes it a conditional offer. And secondly, it is clearly not in accordance with the format prescribed. The format is prescribed only so that there is uniformity in all the bidders submit a clear and unambiguous agreement. That is why the format is given. Otherwise, there was no reason that the format was required to be given.
What's 4.3 here?
Now, my lords will kindly come to the local content certificate that is submitted.
Yes,
Now, my lords will kindly come to the local content certificate that is submitted, which your lordships will find at page 280. Subclause R of clause 3 of the eligibility criteria expressly provides that it has to be in the name of the bidder. Now, this is what it submits. Based on the document and information provided by the management, and as per Government of India order number so and so, so and so, so and so, as a statutory auditor, I hereby certify that capital Messrs. J. Ambe Road Lines, which is one of the constituents, and the local content, etc., is given. Next paragraph, it is stated that he has 50% of local content. Now, your lordship will kindly note the date, 2/8/2024. Now, similar document is submitted in respect of another constituent at page 282. If your lordships will hold both these certificates together with the requirement, which your lordships will find at page 208. Firstly, it is not in the name of the bidder, which is the joint venture. Secondly, the details, most important details, where have you the details of the location at which local value addition is made? That your lordship will find at page 208.
where is that requirement of providing the details of addition of local value in country?
I'm sorry.
Where is that requirement under the instruction to the bidders of indicating the area, the location where the value was added
Malak,
domestically?
this is expressly provided in the certificate, but if your lordship will kindly come to
No, I'm asking I'm asking
Yes, yes,
the instruction to the bidders.
yes, I'm coming to that one. Your lordship will kindly come to page 152. 153. Subclause D at page 183. Local content means the amount of value added in India, which shall be the total value of the item procured, excluding net domestic indirect taxes minus the value of imported content.
That's right. I'm asking for the requirement of indicating the location.
Location, otherwise, how do we know?
No,
If we want to verify, how do we verify?
something different.
Your lordship will kindly,
That certification comes, you believe the certificate of the cost accountant or the chartered accountant. But where is it said that it has to be specifically stated? Because you're not you're non-suiting somebody.
yes,
So, and only on the ground that the content of the.
no, it's not on that ground alone. Local content, my lord, it is not on that ground alone. Now, once these documents were submitted, all the technical bids were opened. What did the authorities do? Coming to the next limb of my submission on facts. What did the authorities do? If your lordship will kindly take up the second volume.
Now, both sides will have to give a compilation volume.
Yes, no,
We
we have
will not-
prepared, Lordship, we can hand it over.
Okay.
Your lordship will kindly come to page 568.
Mr. Saikia, give a copy of the compilation volume to the other side also.
Lordship.
If they have not prepared, we'll take it from yours.
Lordship.
But they must have a copy.
I have prepared a brief written note and indicating all the relevant pages.
Whatever you submit to us, you submit to the.
Yes,
other
yes,
side.
certainly. We cannot be unfair.
Page 582.
568. So once in fact, a little bit off the record, and I have in my experience of about 28 years, I have dealt with quite a few tender matters. I have not seen such a elaborate exercise undertaken by a tender committee. Your Lordship will kindly come to the
And
top.
And you must listen to our experience also.
Certainly.
Over a period of 34 years, with 11.5 years on the bench, I have not found a more complicated thing, which was unnecessarily made complicated.
Absolutely, Lordship. It's open and shut case.
Unnecessarily made complicated.
It's a very open and shut case, in fact.
If your Lordship will kindly come to page, at the top of page 568. The minutes of the tender committee meeting held on 14/8/2024. Now, the tender committee sits, records the basic facts, proceeds, and then at page 571, your Lordship will find that there were 12 tenderers. One by one, they took up each of the technical bits.
No, no, that is a compulsion.
Yes, it's
How do
compulsion.
they consider?
I was pointing out, my lord,
Mm.
what is the consideration with regard to the appellant?
Yes.
That your Lordship will find at page 571 at the bottom,
And he's at number 3.
number 3.
Mm.
So this is the appellant. They proceed to take note of each of the documents submitted till page 573, 574. They find that things are in order.
Mm.
And then 574.
Mm.
In the middle of the chart, your Lordship will find on the left-hand side, your Lordship will find public procurement preference to make in India for local supplier. Bidder submitted the following documents. A certificate dated 2/8/2024 issued by CA Arvind Kumar so-and-so of Arvind Kumar Chartered Accountant or Statutory Auditor, declaring that Messrs. Jai Ambe Road Line so-and-so is a class 1 local supplier so-and-so. 2, a certificate dated so-and-so issued by CA Anuj so-and-so, statutory auditor, declaring that so-and-so private limited is a class 1 local supplier and 100% of local content, etc. Now, the remarks on the right side. Bidder not submitted a certificate in the name of Messrs. So-and-so, that is the JB, issued by practicing cost accountant or practicing chartered account regarding local content as per Annexure 9, capital A of ATC, so-and-so. This is so far as the local content is concerned. Now, next is right at the bottom of the chart, your Lordship will find legal status of bidder. Messrs. Dev Mining Company bidder submitted a copy of a partnership deed, so-and-so, general power of attorney, so-and-so. Messrs. JMB, etc., who has submitted what? And in the right side, your Lordship will find bidder not submitted a clearly readable copy of partnership deed of Messrs. Dev Mining Company. This was the second problem that was found in this technical bit. Now, if your Lordship, bidder at serial number 4 of consortium agreement, lead partner, stated that all the partners of the consortium shall be jointly and severally liable during the bidding process and for the execution of the contract as per the contract terms with the employer. And at serial number 4.3 of 6, that is participation, share and work responsibility, stated that however, all parties shall remain jointly and severally responsible for the satisfactory execution of the project in accordance with the contract terms and conditions. But at serial number 7 and so-and-so stated that all partners of consortium shall be liable jointly and severally to the as mentioned proportionate share to clause number 4 during the pre-qualification and bidding process, and in the event the contract is awarded during execution of the contract in accordance with the contract terms. Then at the bottom, your Lordship will find on the evaluation of the documents submitted online, TC observed that the bidder, the appellant herein, to submit following clarification shortfall document. It is not that we outrightly reject it. And then the final recommendations your Lordship will find at page 583. This is the recommendation made by the tender company. Technical clarification shortfall documents to be sought from one bidder, namely so-and-so. That is this one, the appellate here. In fact, he was the only person who was given the opportunity. Now, he responded to this without any complaint whatsoever. He responds to this and submits the clarifications online. And then, if your lordship will kindly come to the page 584, the tender committee now meets after the clarifications are submitted by the appellant without any other objection whatsoever. Minutes of the tender committee meeting held on 22/8/2024 for hiring of etc. etc. Now, towards the bottom, your lordship will find a chart has been prepared. They proceed query wise. On the evaluation of the documents submitted online, DC observed that the bidder Messrs. So-and-so to submit the following clarification shortfall document. Query 1, bidder to submit the certificate in the name of so-and-so issued by practicing cost accountant or practicing chartered accountant regarding local content as per Annexation 9 capital A of ATC of bid document. Response, the bidder submitted a certificate dated 17/8/2024 issued by CA so-and-so of the so-and-so in the name of so-and-so issued by the statutory auditor practicing chartered accountant regarding local content is more than 50% and above, which meets the local content requirement for class 1 local supplier and signed on date 17/8/2024 with UDIN number so-and-so. Second query, bidder to submit the clearly readable copy of partnership deed of Messrs. Dev Mining Company. The bidder, next page, the bidder submitted a clearly readable copy of partnership deed of Messrs. Dev Mining Company. Query number 3, they again elaborate what was the deficiency. And response 3, your lordship will find, bidder resubmitted the copy of the working capital certificate in response to this query. And thereafter, they again proceed to consider, and page 587 and 588 are the findings recorded by the tender committee. 587 towards the bottom, public procurement preference to make in India. Towards the right-hand side are the findings of the tender committee. As the document of local content submitted against the clarification is dated 17/8/2024, that is the date after the bid submission end date, 5/8/2024, bidder does not fulfill the eligibility criteria as per requirement of bid document. Then next, legal status of bidder, and the findings are on the right side. The submitted document regarding consortium agreement is not in line with the format provided at Annexure 2 of ATC of bid document. Therefore, the bidder does not fulfill the eligibility criteria as per requirement of bid document. And accordingly, if your lordship kindly turns to his bid was recommended for rejection, 590. Bottom of that chart at the top. On the evaluation of the documents submitted online, TC observed that the bidder Messrs. So-and-so submitted by so-and-so does not fulfill the eligibility criteria as per the requirement of bid doc. And thereafter, they say that the price bid of the technically qualified bidder may be opened, and accordingly a date is fixed. After that, the petitioner, appellant, submitted a representation that your lordship will find at page 288 in the first volume.
Yes.
By referring to page 278, a submission was advanced that there was some problem with the website. In the entire, I'm not troubling your lordship, my learned friend will correct me if I'm wrong. In the entire representation, not even a whisper that there was some problem with the website. This is a point developed at the time of filing of the writ petition. This was never, even assuming there was, it was never ever brought to our notice. So what they say is we have complied, but if you want any further clarifications, we are willing to give. But any problem with regard to the website, your lordship will not find any mention in this. In spite of that, since a representation was submitted at page 288 on 23/8/2024, the tender committee once again meets to consider this representation. That your lordship will find at page 595, second volume. Subject, minutes of the tender committee meeting held on 26/8/24 for work of hiring of so-and-so, so-and-so. Tender committee in its meeting held on so-and-so observed that the following 11 bidders did not fulfill the eligibility criteria, etc., etc. Remaining one bidder fulfills the eligibility criteria as per requirement, etc. Accordingly, tender committee in its meeting dated 22/8/24 recommended for obtaining approval of price bid of Messrs. So-and-so as per clause 19.2 of so-and-so. After obtaining approval of CMD CIL, technical evaluation was done on GM portal and financial evaluation can be opened only 48 hours after completion of the technical evaluation, scheduled financial opening date and time, 24/8/2024, 8 p.m., etc. Meanwhile, Messrs. JRPL, etc., the appellant, represented by JPW Infratech, submitted the representation against the disqualification as per GM portal functionality on so-and-so. And then an elaborate consideration on each of these aspects on the points raised in the representation are considered. 596, 597. Tender committee deliberations are elaborated, all recorded in details. It goes on. And finally, they say that we cannot consider this representation and accordingly it is rejected. In the meantime, on 30th of August last year, financial bids were opened. The price analysis was done by experts. It was found to be adequate.
Out of 12, how many of them cleared the technical evaluation?
Only one.
Only one.
And there's a difference of 112. My price,
Does not matter. We did not know the price.
I'm just informing the court. My price is 12 crores less.
That is
And
something.
all 11s were rejected, only 1%.
Both of you know the law that is not the consideration, but
Yes,
then
yes.
nonetheless, that information is
Uh,
relevant. for
That is something we could not have known when the decision-making process was going on. Now, after that, as I was pointing out to your lordship, on 30th of August, the financial bid was opened, price analysis was done by experts, and
And how about this, when only a single tenderer could qualify?
that is nowadays your lordship is aware, Manoj.
Only free tender.
No, CVC has since 2021, CVC has now clarified that it cannot be as a routine matter be put to retender because it entails a lot of cost. That document also I can straight away place. It is part of the record.
Something which concerns more than 1,000 crores. And a public sector company.
So, because the policy has since changed.
Mr. Chaudhary remains the only person in the fray. Whatever cost he offers, that will be accepted.
One can look at it like that. Manoj. Earlier, what was happening was the CVC had. It is, if your lordship will kindly come to, that aspect is dealt with at page 405. It forms, this was one of the points urged,
Page 405 of?
volume 1. It starts, the procurement manual starts at page 308. This is page 308, it starts, and the relevant portion is at page 405.
308.
308, it starts. It's a very voluminous document.
Just a minute. Manual for procurement of work. Yes.
And page 405 is the. And this is pursuant to the new CVC guidelines.
5.6.8.
Page 405, clause 5.6.7. Consideration of lack of competition. Sometimes against advertised limited tender cases, the procuring entity may not receive a sufficient number of bids and or after analyzing the bids ends up with only one responsive bid, a situation referred to as single offer. As per Rule 21 of DFPR, explanation subpara so-and-so, such situation of single offer is to be treated as single tender. The contract may be placed on the single offer bidder provided the quoted price is reasonable. However, restricted powers of single tender mode of procurement would apply. Before retendering, the procuring entity is first to check whether while issuing the inquiry, all necessary requirements and formalities such as standard conditions, industry-friendly specifications, wide publicity, sufficient time for bidding, and so on were fulfilled. If not, a fresh inquiry is to be issued after rectifying the deficiencies. It has become a practice among some procuring entities to routinely assume that open tenders which result in single bids are not acceptable and to go for retender as a safe course of action. This is not correct. Rebidding has costs. Firstly, actual costs of retendering. Secondly, the delay in execution of the work with consequent delay in the attainment of the purpose for which the procurement is being done. And thirdly, the possibility that the rebid may result in a higher bid. Lack of competition shall not be determined solely on the basis of number of bidders. Even when only one bid is submitted, the process may be considered valid provided following conditions are satisfied. One, the procurement was satisfactorily advertised and sufficient time was given for submission of bids. The qualification criteria were not unduly restrictive. Number three, prices are reasonable in comparison to market values. So the routine.
It's a not complete no. Because the
Yes, sir.
the restrictive procurement mode has to apply. The law has not changed since then. This is only the Government of India, Ministry of Finance, Department of Expenditure manual for procurement. But normally, now read, however.
Restricted powers of single tender mode of procurement would apply. In case of price not being reasonable, negotiations being L1 or retender may be considered as justifiable. Unsolicited offers against LTEs should be ignored. However, ministry's department should evolve a system.
Therefore, it is not a complete no.
It cannot be a complete.
It cannot
I'm
be
not
a
even.
complete no. The law remains the same.
I'm not saying that it is a complete.
Otherwise, how do you find that the price is reasonable or unreasonable?
That is why I was pointing out to your lordship. In fact, let me place that document. If your lordship will kindly come to, since it was a single tender, single technical bid that qualified, your lordship will kindly come to page 600. Since it was only one person left in the fray.
Let us see the manual first. Yes, you were doing something.
Page 600. Since there was only.
Before that, Mr. Chaudhary, could you please take us to the relevant portion? What is the restricted powers of single tender mode of procurement?
That is something I'll have to perhaps go into a little bit into. It's a
Clearly, because this aspect escaped the attention of the single judge. On the question of
This was not even urged.
Let it not be urged, no. Let it not
I
be
did
urged.
urge about the value. I did urge.
No, that
No,
That's
value
one of
is
the main
something else.
ground also in my.
Value
That's
I could
something
not have
else.
known.
Value is,
Hmm.
that law is very clear. Value is not to be taken into consideration. That's upon the employer. Not necessary that L1 or H1, whichever is the case, has to be employed. That's
We have,
something else. Now, in case of single tender, because we are really cautious about single tenders, this happens only in a retender. If there are no many, I mean, if a single tenderer remains in the fray, the entire procurement process is put to a retender. If in retender also there is one person in the fray, then perhaps one can go. But otherwise, we would like to know what is the restrictive power of single tender mode of procurement? What is to be seen there?
For that, I have to be very candid and honest.
No, no, that's
That is
right.
an area I have not examined.
We don't blame you for that. This is something out of the blue, no?
Because this was never heard, all these are.
Till the time that we were hearing all of you, we only thought that it was, I mean, one amongst the many Mr. Chaudhary fell, came out successful.
What had happened? Now, on facts, it cannot be said to be a case where there was lack of participation.
Any one of you, any learned senior advocates for the parties, what is this restrictive power of single tender mode of procurement?
This is something I don't think, because this was,
This would strike at the root of the matter, no?
For that, your lord.
India Ministry of Finance, instruction in this regard, which you have annexed in our affidavit. So not to kindly come to take 84.
Of the second volume.
In page 115 also,
This comes to page 685. About 11.8. Rejection of single bid. It has become a practice among some procuring entities. Routinely assume that open tenders which result in a single bid are not acceptable and to go for retender as a state government. This is not correct.
No, that's all, that is there.
And you see, rebidding has cost. Firstly, the actual cost of retendering. Secondly, delaying execution of the work to and delay in attainment of the purpose for which the procurement is being done. And thirdly, possibly that rebid may result in a hard sale. Lack of competition is not determined solely on the basis of number of bidders. Even when only one bid is submitted, the process should be considered valid.
There's the same
Provided
thing,
the following conditions are satisfied.
same thing under the, that's something.
guideline.
See, you proceed ahead.
Yes,
Now, Mr. Chaudhary, there are two stages to it.
yes.
Single tender, it's a not complete no, because of the cost of the tender, because of the delay in the process and all that.
Cost escalation.
And when you say yes to a single tender, these three things are to be there. The
Yes.
procurement was satisfactorily advertised.
Procurement was satisfactory.
That is true because there were 12 bidders.
Yes.
The qualification criteria were not unduly restricted because all of them participated, nobody questioned.
Yes.
Prices are reasonable in comparison to market values. That
These are the three considerations.
That's right. So the next stage would be
Yes.
that if you consider the single tenderer and you analyze his price offer, then what considerations have to weigh? This is the separate kind of a mode which has been prescribed.
Correct, Milord. The third option also has to be exercised, whether. the
No, that's
price-
not an option. Mr. Chaudhary, that is the difficulty. Suppose,
It must. reflect
Just-
the
just-
market value.
just listen to the court.
Yes.
Now, in any contract, in any tender, if one person remains in the fray, all right. The employer or the procurer could proceed with it, provided three conditions are set.
Conditions are fulfilled.
Done. Now thereafter, the ball is in the court of the employer to apply another mode for assessing the price valuation, the price offer of the single tenderer. That is the mode which has been talked about in that document which was pointed out to him. What is the requirement? Whether your bid was tested on the anvil of that
On the
requirement.
ambience of those.
This-
Number three.
That is what I was coming to.
This is all right. This we understand. That
Now,
sing-
that is answered, Milord. Please come to page 607. Same document, Milord. Yes. Somewhere in the middle, Milord, after rejection, and come to at page 607. After rejection of the appeal representation of so and so, the price bid of technically qualified bidder was opened on 28/8/24. And the system displayed the comparative chart showing Mahalakshmi so and so. The quoted amount by resultant single bidder is 103.24% of the base value. That is 3.24% above the estimated value. the result of open tender and market driven rate. There is a net positive margin in all the 6 scenarios suggested by the technical committee. In absence of SO, the estimate was prepared considering the awarded rate of 3 contract awarded at NEC. For those cases where award rates are not available for that lead slab, the rate were derived considering the simple averaging the variations in the rate of different lead slab in each work order, and the same has been added in the awarded rate to derive the rate of the new lead slab. After that, the derived rate is uploaded considering the PVC of the CMM chapters also. The final estimated rate put to tender for the subject work is lowest value derived from the 3 contracts. So, it's not that the consideration has not been followed. Even by applying the 3rd criteria also, my lord, relevant considerations were taken over. And please skip over to the next page, my lord.
Let him complete.
In fact, I was coming to this very document.
Just. This is the justification for accepting the single tender and not allowing it for rating. This is the justification. This is over. Now, with a single tender, there is which change that we just read. Yes.
In fact, this is the document I was coming to. At page 600, it starts.
Perhaps there is
After-
there is a subtle distinction in what you're saying and what we are understanding. These 3 grounds that you have just read, what Mr. Chaudhary read, these are justification for allowing a single tenderer to participate in the financial.
No,
Otherwise, it cannot be. That is the thing. See, single tender, the procurer does not go for a retender, does not advertise it again. Why? Because of these reasons. He sees that the advertisement is satisfactory, number 1. Number 2, price is not, conditions are not restrictive and price is reasonable. Agreed. Now, what I am asking is something anterior to it. Now, after this justification is there on record, the entire mode of procurement from a single offerer, single tenderer becomes a different exercise. That's a different thing altogether, which the manual says. Manual for procurement of works, the updated one.
In other words, Lord, whether reasonableness of the price was tested.
We don't know, no.
That is the exercise subject to what you're also saying.
I'll just.
Page 106 and also 608. Please come to 608 for a moment.
We have seen that.
Yes.
Now, please, this.
Undertaking by tender committee regarding award of work to result in single tender as follows.
Prescription.
These 3 considerations were adverted to below.
No, I'm only asking for one thing.
Yes.
Now, what is this mode of procurement in a case of single tender? Is this the one? No, there is something else.
Normally, earlier practice was in case of a resultant single tender, normally go for retail. Now, this policy was reviewed and it was found that at times it leads to a cost escalation and all. Might as well lay down some criteria and permit this. And these are the 3 criteria. So
this is the code that this manual is talking about.
Yes.
Which page? The first document that you were showing, page
405.
405. No, it is there. See, look at this. Come to page 405, Mr. Chaudhary.
Second.
405.
Your lordship is referring to however restricted powers of single tender mode of procurement.
That is the only thing that is stopping us here. Well, read this. Even when only one bid is submitted, the process may be considered valid provided following conditions.
Yes.
So this is the justification for holding one tender valid. That's what you're right. Absolutely correct. And then says, however, after the 3, however, the restricted powers of single tender mode of procurement would apply. What is this mode of procurement?
It would be
Both of you are absolutely justified. Single tender, this is the manual, everything.
that would entail in my humble understanding. That would entail that merely because only one.
That cannot be an inference. If there is a mode prescribed, all right. If not, then we will infer.
And subject to correction, although it's a very voluminous document, I have not gone through the whole document. But there is no specific mode prescribed.
It appears to me to be so, because the documents that Mr. Chaudhary was reading, this talks about some process, could be, but has it been delineated here?
I think something is missing in this sentence.
No, it is not. No?
However, restricted powers
No,
of single tender.
If you read,
As if there is something, some more.
Yes, that is what it is.
so this is therefore I was always harping on this. This is the justification. You are justified in not putting it to retender on these reasons. Procurement was satisfactorily advertised. Qualification criteria was not unduly restrictive, and the third one, prices.
Reading the next sentence, perhaps may not, it obliterates that.
We are only asking you to point out from the manual. You don't need to scout for it elsewhere. From the manual, if you could find out, all right. Otherwise, we will infer, because if these three things are the indices on which this procurement mode would depend upon, all right. But if there is another mode prescribed in the document, tell us.
Subject to correction, my lord. No.
You appear to be right. There's no difficulty.
Because if your lordship will kindly proceed to the next sentence, what it says is this. However, restricted powers of single tender mode of procurement would apply. In case of price not being reasonable, negotiations or retender may be considered as justifiable. Unsolicited offers against so and so. So what it says essentially is once you have gone into this.
Just for our satisfaction.
Yes, I appreciate.
Just go through this manual for the procurement works and find out if there is anything.
Yes, certainly.
We are not asking you to go scouting for this criteria elsewhere.
I understand. Now, my lord, my respected senior colleague, Mr. Chaudhary, has already placed the document. If your lordship will kindly have that page 600. Once the representation was rejected, it's not that they whimsically, simply, since this was the only person left in the fray, we will accept whatever he has given. What they did was, page 600, it starts. The tender committee undertakes another elaborate exercise to analyze the price. It starts at page 600 and carries on. Each of the components of the work are taken in note of. Your lordship will find technical details, etc., are all analyzed. Thereafter, they proceed. At page 605, your lordship will find a profitability statement. Then page 606, your lordship will find individually components are taken note of. Thereafter, a comparative analysis is made at page 607, my learned friend pointed out.
It has to be this kind of an analysis only.
Yes. So what I was trying to point out to your lordship that even though there was only a single person left in the fray, they still undertook an elaborate exercise as regards the price itself, whether it is reasonable or not. And making a comparison with 3 other similar works.
Now, you will find it at page 608, the last, thus considering the above deliberation. So this is the deliberation also, this is the justification. I think this is the mode that they are talking.
Thus, your lordship is referring to the last.
Idea, if you can find out anything else, this is the mode that they are talking about in single tender. So that ground goes.
Which is 100, and if lordship is pleased to come to 607.
No, 608, I'm asking you to.
Yes. No, 607 is more than 100% of the base price.
No. 100% that decision, we are not questioning.
Lordship.
The entire process, the mode of evaluation, especially in case of a single tender left in the fray.
No.
So this, perhaps we were talking about some mode, but no, it appears from the reading that these are the 3 indices which have to be checked in single tender, and they have analyzed whether correctly, whether you're non-suiting. This is a different point altogether, not what you have argued. But I think it is the same thing that they are asking about. You're saying something, Mr. Chaudhary?
No, I think we'll have to, subject to correction, we'll have to check the video. I think this point was given up by the petitioner before the last.
No, I have not given it. I have very,
We have to check up a lot.
No, that ground, whether,
In any case,
Mr. Chaudhary, whether,
I'm not saying it
In
in
a-
a.
of course, in letters, patent appeals or writ appeals, that assumes importance. But for our satisfaction, we can always
Right.
take it into account, whether he
The
drops
impact
it or whether he takes it. So now this deliberation appears to have gone. Technical non-suiting is something else that we are seeing, but to justify your existence here is this deliberation we have seen. They have done it. They have
All-
done it. Yes.
Two important facts.
Hmm.
After all this exercise, the work order was issued, these two dates, these have happened during the course of the proceedings. Your lordship may just make a note of these two dates. The LOA was issued on 31/12/2024, and the agreement was signed, contract agreement was signed on 10th of February 2025. Now, coming 15th of February 2020. Now, coming to the submissions, if your lordship, I would not like to trouble your lordship with all those clauses again. In the evaluating criteria, your lordships must have noted that the entire responsibility of undertaking the decision-making process is imposed on the tender committee. Normally, in most of the tenders, it is not expressly provided. Here it is expressly provided, and it is that recommendation of the tender committee, which is finally.
No, Mr. Chaudhary, does that, I mean, your case is on a different footing. Does that improve your case?
So I was just,
Question is tender committee only evaluates, no, but the responsibilities of the procurer.
here the recommendation is to be made by the tender committee, as per the conditions of the evaluation itself. May I straight away point out?
But that takes you nowhere.
No, what I was trying to point out to your lordship is on two technical objections. One is that all these tender committee minutes form part of the records. Firstly, the tender committee is not even made a party. And secondly, none of these recommendations made by the tender committee are put to challenge. These are two technical objections that we are raising. And as I said, technical, these recommendations are not under challenge. Now, coming to the legal.
Coal India with its subsidiaries, they have been implemented as party, that's good enough.
As I started off by saying, using the word technical object. And
Yes.
now, here, what is it that the authorities have done? What the authorities have done is they have stuck to the letter and spirit of the conditions. Two things. There is a format so far as the consortium agreement is concerned. There is a specific format provided in the NIT. It would have been a different matter that merely conditions are given and the format is not given. So everyone would be at liberty to use their own language. Here is a situation where the format with express words and phrases are given, that this is how you are supposed to give. And he did not give it. So we stuck to what we had declared. We had declared that we will go by these declared norms. These are the standards by which we profess our actions to be judged. And we have stuck to it. On that, my lord, I am placing reliance on two judgments, my lord. One is obviously the famous judgment of Ramanna, and the other one is Vidarbha. If Ramanna is, my lord, 79(3) SCC 489. I'll read out. The paragraph itself is very long. I won't trouble your lordship with the whole paragraph, just the relevant portion. Uh, 79, volume 3 SCC 489. Separate. 79, 3 SCC 489.
Not Purano, there is an old one. R.D. Shetty versus International Airport. There's an
Right.
old one. Many new cases have come, but none.
Yes, but I was just wanting to refer to one sentence, one, at paragraph 10. That your lordship is aware, is a very long paragraph, just at page 503. Towards the bottom of the first sub-paragraph, line about 5 from bottom, this is a sentence starting, it is a well-settled rule. Have my lords gone.
Yes,
It is a well-settled rule of administrative law that an executive authority must be rigorously held to the standards by which it professes its actions to be judged. And it must scrupulously observe those standards on the pain of invalidation of an act in violation of them. So here is a case, we had declared a set of norms in the tender that we will not accept documents which are not historical documents, which did not pre-exist prior to the date of the opening of the tenders. We have declared a norm and we have stuck to it. Now, on the same issue, the second judgment I would rely on is Vidarbha, that is 2020 volume, slightly more recent judgment.
we take leave of 5 minutes. Come back again.
Welcome break one for all. I was in the process of placing Vidarbha irrigation, that is 2020, volume 17 SCC. 577. Here is a case where some conditions were condoned in respect of a particular tender. And this is what the apex court had to say about that, paragraph 16. Paragraph 16, which your lordships will find at page 586. Judgment starts at 577.
Yes.
Para 16 at 586. It is clear, even on a reading of this judgment, that the words used in the tender document cannot be ignored or treated as redundant or superfluous. They must be given meaning and their necessary significance. Given the fact that in the present case, an essential tender condition, which had to be strictly complied with, was not so complied with, the appellant would have no power to condone lack of such strict compliance. Any such condonation, as has been done in the present case, would amount to perversity in the understanding or appreciation of the terms of the tender conditions, which must be interfered with by a constitutional court. So if such a requirement is condoned, your lordships would interfere. Now, your lordships would recall the judgment of G.J. Fernandez, 1990, volume 2, SCC 488. And again, I'm relying on para 15. It's a very long paragraph. I'm not troubling your lordship with the entire paragraph, just one sentence. I'm trying to cut short as far as possible, man. If I'll read out that just one particular sentence.
All people photos connected.
Para 15 at page 501. Thirdly, the conditions and stipulations in a tender notice like this have two types of consequences. The first is that the party issuing the tender has the right to punctiliously and rigidly enforce them. And it can be, and later, in the later part of the paragraph, as your lordships are aware, the Supreme Court proceeded on to discuss what are the situations in which a lenient view can be taken. Only when such a lenient view is uniformly taken in all respect of all tenderers, only then leniency can be allowed. Otherwise, it has to be punctiliously and rigidly enforced. Now, one of the sheet anchors of the appellant is that the price is low, which I am not troubling your lordship. Your lordship is aware of the law. Here is a situation, in my humble understanding. Assuming the arguments of the appellant are accepted in its entirety, what is it that is the result? At best, he is presenting another possible view. The authorities, who are the authors of the tender document, they have adopted a view which might sound a little rigid, that we have strictly gone by the letter and spirit of the conditions. And the appellant might succeed in presenting a view that they could have been or should have been a bit lenient on these aspects. If that be the situation, what is the law? Your lordships, on this issue, I'd like to place two judgments, my lord. Shilpi Construction is one. That is also a recent judgment, 2020. 2020, volume 16 SCC 489. Paragraph 20. Para 20th, page 501. Have one, Lord's Court.
Yes.
The essence of the law laid down in the judgments referred to above is the exercise of restraint and caution, the need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of its requirements, and therefore the court's interference should be minimal. The authority which floats the contract or tender and has authored the tender documents is the best judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The courts will only interfere to prevent arbitrariness, irrationality, bias, malafide, or perversity. With this approach in mind, we shall deal with etc. Here is a case, no malafide is even alleged, much less anyone even named. Now, next is a more recent judgment of NG projects. This is 2022, volume 6 SCC 127.
I am smiling for one reason. If public interest is the consideration, then perhaps no commercial litigation would be maintained. It's all-
And we would always be on the receiving end if we are on that side.
Yes.
It's 2022, volume 6 SCC 127. And the relevant paragraph is paragraph 7. Uh, 22 and 23, sorry. Para 22 at page 144. The satisfaction whether a bidder satisfies the tender condition is primarily upon the authority inviting the bids. Such authority is aware of expectations from the tenderers while evaluating the consequences of non-performance. In the tender in question, there were 15 bidders. Bids of 13 tenderers were found to be unresponsive.
Yes, yes, the same principle. All right.
Only when it is actuated by malice, only then your lordships would interfere. And then, my lord, my last limb of my submission. If your lordships, I am again, my learned friend has placed some portions of the judgment. Your lordship may just make a note of the relevant paragraphs in which each of these aspects have been dealt with. so far as the local content certificate is concerned, the issue has been dealt with by the learned single judge at paragraphs 46, 47, 50, 51, and 52. Taking note of each of the tender clauses, the local content certificate issue has been dealt with at paragraphs 46, 47, 50, 51, and 52.
Yes.
Then the joint venture agreement aspect has been dealt with by the learned single judge at paragraphs 57, 58, and 59. And that it is not in the format. Findings have been recorded at paragraphs 61 and 62. Now, an argument was also advanced that they will give their individual certificates and that will be added up and that adding up has to be done by the authority. That does not pertain to local content and agreement. That pertains to the experience. And that aspect was urged before the learned single judge, and it was dealt with and negated at paragraph 63. And the learned single judge, we pointed out that wherever individual certificates were required, it was expressly provided. Like, for example, there cannot be a PAN number for a joint venture. So it is expressly provided in the NIT that the PAN card of the individual constituents will have to be given. GST registration of the individual have to be given. So wherever individual documents are required, the NIT specifies. Now, the fact that the bid is much lower, that has also been dealt with at paragraph 65. So by pointing out these aspects, what I was coming to is this one. Here is a tender authored by Coal India, interpreted by Coal India, by experts. That now has been upheld by the learned single. Whether in an intra-court appeal, your lordship should reverse. And on that, there are two division bench judgments of our court. I am not troubling your lordship.
No, please tell us.
One is 2004, volume 1.
You're referring to Supreme Court.
No, our High Court division bench.
They must have followed some Supreme Court judgment.
Yes, this is my lord. This judgment is authored by Honorable Justice Ansari, and very long judgments on two aspects: necessary party and this aspect. How an intra-court appeal is to be dealt with. Para 26 at page 135. In fact, this is a case where myself and the senior Mr. Chaudhary were at loggerheads. Para 26. While dealing with the present appeal, one has to bear in mind that a writ appeal is really not a statutory appeal preferred against the judgment and order of an inferior court to a superior court. The appeal inter se in a high court from one court to another is really an appeal from one coordinate bench to another coordinate bench. And it is for this reason that a writ cannot be issued by one bench of the High Court to another bench of the High Court, nor can even the Supreme Court issue a writ to the High Court. Thus, unlike an appeal in general, a writ appeal is an appeal on principle. And that is why, unlike an appeal in an ordinary sense, such as a criminal appeal, where the whole evidence on record is examined anew by the appellate court, what is really examined in a writ appeal is the legality and validity of the judgment and or the order of the single judge. And it can be set aside or should be set aside only when there is a patent error on the face of the record or the judgment is against the established or settled principle of law. If two views are possible and a view which is reasonable and logical has been adopted by a single judge, the other view, howsoever appealing such a view may be to the division bench, it is the view adopted by the single judge, which should normally be allowed to do. This is what I was relying. And similar in line is another judgment, another division bench. I'm not troubling your lordship. So therefore, my lord, looked at to sum up, we laid down certain parameters for our actions declaring certain norms, that this is how our actions would be judged. Those actions were laid down in black and white. That, so far as the local content certificate is concerned, we said that you did not comply with when we asked for a clarification, you gave a new document, which is not a historical document, which did not pre-exist. That's the ground. And so far as the joint venture agreement is concerned, we say that it's not in the format prescribed. We simply stuck to what we had declared. And if it is looked at from the other angle, had we relaxed this, overlooked, and a third party comes, what would be the consequence? So therefore, my lord, looked at from all perspectives, the learned single judge has rightly, my lord, rejected the writ.
Yes,
I'm obliged.
There's hardly anything left.
you adopt the arguments of Mr. Chaudhary.
I do that. Just a little bit, my lord.
Yes, it's, oh, we are not cutting you short.
If your lordships would kindly have page number 595,
Volume 1.
volume 2, my lord. That is when, my lord, the representation or appeal which was filed by the appellant, that was considered. Where, my lord, everything has been taken note of at page 597. 598 and 599. My lord, as far as factual aspects are concerned, my lord, there is hardly any scope to make any argument. All that I'm trying to say is, my lord, now if your lordship kindly comes to page 598, conclusion. Towards the bottom of page 598. Bidder did not submit the clarification against the query sought and submitted a copy of the working capital. The submitted document regarding consortium agreement is not in line with the format provided at Annexure 2 of the ATC of the bid document. Therefore, the bidder does not fulfill the eligibility criteria as per the requirement of the bid document. In view of above, the tender committee stands with its earlier recommendation that bidder Messrs. So-and-so does not fulfill the eligibility criteria as per requirement of the bid document, and their appeal needs to be rejected. GM portal mentioning the following remarks. The submitted consortium agreement is not in line with Annexure 2 of ATC. Bidder, a consortium, did not submit required document, that is, my lord, local content certificate. So these are the two principal grounds on which, my lord, the bid of the appellant was initially rejected, and on appeal, my lord, after referring to the relevant requirements envisaged in the bid document, my lord, it was reiterated. Now, my lord, I am asking a question to myself. What is under challenge in this proceeding, my lord? At what stage the petitioner approached this honorable court? The petitioner, the appellant approached this honorable court at this stage when his technical bid was rejected. During the pendency of the writ petition before the learned single judge, certain development took place. Now, was it not incumbent upon the petitioner to bring on record all those? Because, my lord, the principle of merger is applicable even to administrative decisions. Now, at least this appellate order should have been challenged. It is not under challenge. So therefore, my first submission is the appellate order is not under challenge, therefore it is fatal. And I'm relying on Supreme Court judgment, my lord, Punia Ahmed's case.
This is not an appellate order, Mr. Chaudhary.
Yes, this is an appellate order.
No, this is on the representation.
Yes, that representation.
That's right, but.
So
this-
that has merged.
No, that is merged, that is all right.
Yes.
Then this is by the technical committee only.
Yes.
So therefore, this cannot be an appeal.
No, I'm not, the expression
Yes,
appeal
right.
may not be appropriately applicable, but my lord, what was under challenge before the learned single judge? So initial decision that was reiterated by another order, by speaking order. So was it not incumbent, my lord? So my humble submission is, if it is not an appellate order, at least this order of 26/8/24 or the order of 22/8/24, which was the initial order that merged with this order, and this order has not been challenged. Then, my lord, I'll just place that citation, my lord. Kunia Ahmed's case, 2006 FCC 359, para 12, my lord. The principle of merger applies even to administrative order. All right. Yes. Now, my lord, let us come to the scope of judicial review in these matters. That is essentially the only question left. Now, my lord, in state of West Bengal versus Patel Engineering, the Supreme Court has said a very lucid thing, my lord. Best way to ensure transparency is to follow the tender conditions. Now, I'm not going to that extreme, my lord, NJ Exports case. I personally, I don't cite the judgment often because I appear on this side also. That's not a judgment to be cited, my lord. That's an extreme view, my lord. Otherwise, my lord, Article 14 makes no sense. Otherwise, my lord, the power of judicial review against contracts should be deleted. Or Supreme Court should say that henceforth contractual matters should either go to the civil court or arbitration. 226 courts should not interfere. Otherwise, my lord, it makes no sense. Therefore, I always say that's a judgment. Of course, in Jai Bholanath, Jai Bholanath, that order has been explained. Now, the question is, my lord, if the authority, after scrupulously following the tender condition, rejects a tender, a technical bid, when can it be still said it's an arbitrary exercise of power? That is where, my lord, that the West Bengal case assumes importance in our case. The citation is, my lord.
Just read the relevant portion.
Yeah, just give you, I'm not, yes. 2001, 2 SCC 451, para 24. My lord, I'll not even read it, I'll just read 2-3 sentences, my lord. The degree of care required in such bidding is greater than ordinary local bids for small work. It is essential to maintain the sanctity and integrity of the process of tender and also award of contract, etc., etc. The appellant, respondent number 1 to 4 and respondent 10 and 11 are all bound by the ITB, which should be complied with scrupulously. In a work of this nature and magnitude where bidders who fulfill pre-qualification alone are invited to bid, adherence to instructions cannot be given a go-by by branding it as a pedantic approach. Otherwise, it will encourage and provide scope for discrimination, arbitrariness, and favoritism, which are totally opposed to the rule of law and our constitutional values.
This is Patel Engineering.
Patel Engineering. Last sentence, my lord, we therefore have no hesitation in concluding that adherence to ITB or rule is the best principle to be followed, which is also is in public interest. Now, the other day, my lord, I was dealing in a contractual matter where your lordship has also said, in this matter, some little non-compliance is good enough. Now, here in this case, there is a case where there is a non-compliance on the part of the petitioner appellant. Therefore, my lord, the learned single judge has not committed any. Is it a case where it can be said any arbitrariness has crept in the decision-making process? Is it a case where any irrationality has crept in the decision-making process? Is it a case where any malafide has been alleged or even, my lord, brought out to the notice of this honorable court? My lord, bona fide the authority exercise the power. Therefore, Silpi construction will come into play, my lord, where a decision is taken bona fide. And at the end of the day, as my learned friend Mr. Indranil Chaudhary has pointed out, writ appeal is an intra-court appeal. It's an appeal in principle. Merely because another view is possible, it is not always necessary. End of the day, my lord, here was a case, perhaps there was one area where the court should express its concern because it was a single bid, whether the nature required care was taken, care and caution as envisaged by the CBC guidelines and the guideline of the finance ministry whether that was adhered to or not. As is evident from the affidavit of the Coal India at page 606, 607 and 608, my lord, that principle was also scrupulously followed. Therefore, my lord, I don't see in my humble submission, but your lordships may say that any arbitrariness has crept in the decision-making process, which calls for any interference in this case. End of the day, my lord, even if it was a minor non-compliance, that is good enough. Because it's a cutthroat competition, my lord. End of the day, my lord, you scratch my back, I'll scratch your back. So there's no end to it. And my lord, that Sora Builders case, also, my lord, Supreme Court has taken a similar view. I'll just give this citation, my lord. That is 2009, 11 SCC, page 9, paragraph 26. 27, 26 and where, my lord, West Bengal case was relied upon. I'll just reading para 27, my lord, short paragraph. Following the aforesaid legal principles laid down by this court, that is West Bengal, we are of the considered opinion that respondent 1 was negligent and was not sincere in submitting his pre-qualification document within time schedule laid down, despite the fact that he had the information that there is a time schedule attached to the notice inviting tender. Despite being aware of the said stipulation, he did not submit the required document within the stipulated date. Pre-qualification documents were received by the respondent university only after the time schedule was over. The terms and conditions of the tender as held by the Supreme Court are required to be adhered to strictly. And therefore, respondent number 2 university was justified in not opening the tender submitted by respondent number 1 on 1/12/2008, which was late by 3 days. According to us, no grievance could also be made by respondent number 1 as lapse was due to his own fault. Well, at the end of the day, I think the West Bengal judgment, these are all relying upon Ramanna, Dayaram, Sethi and all these cases, my lord. If a condition is laid down, it is for both employer as well as employee to follow it. So, my lord, here is a case I don't find, my lord, those elements are present, which are normally now required because of the restriction which has been brought in the scope of judicial review over contractual matters, my lord. That being the position, my lord, the learned single judge in my humble submission has not committed any illegality which calls for correction at your lordship's hand in exercise of intra-court appeal, my lord.
All right, yes, Mr. Secretary.
Yes, Lordship, I have 2-3 very short points. And all the conditions, all the facts were placed, but they
One
have.
second, my lord. And regarding this single bid, that's not the ground of appeal. That's all. There is no ground.
That's true. Mr. Chaudhary, that struck me most, strongly.
Yes.
So let that not be a ground for Mr. Saikia or for you to respond, but I mean, that we are
as a court,
satisfied.
of
The
course.
Manual we have seen.
We have very
Yes.
categorically stated in 4 paragraphs in the petition regarding that it should go for retender, and I made submission on that. Retender point that was not recorded.
No,
that
but
is
then it is not a no. I mean, I was not aware of this manual. Because most of
Yes.
the tender matters that I handle, there, if one person was there, one party was there, it was always put to retender.
Yes.
And in retender also the same party, then you can
Then
go
it
ahead.
is, because in our government also we do the same thing.
Yes.
A second opportunity has to be given. That is a normal procedure. But now all the clauses were placed before this honorable. There is not a single clause in the tender or in the additional instructions that the consortium agreement has to be submitted in the format, in the same format. There is no such clause. What they have indicated that what are the conditions to be inserted in the clauses that has to be indicated. That is in clause 2. Various parameters has to be indicated. And number 2, there is not a clause in the tender agreement which requires that the local content certificate must be in the name of JD. It is totally vague, totally silent. No indication. They can even counter now. I could not find it out.
The format provided,
That is just for a indication that
Like-
we have to follow.
like the format provided in pleadings and practice.
Yes.
And necessarily the
Yes.
advocates must not follow that. This
Yes.
is what you want to have.
Absolutely, Lord. But it should contain what are the requirements. The requirements must be there in our agreement. Those requirements we fully comply.
All right.
Number two, my learned senior friend was saying that the response to the representation should have been put to challenge. It was neither uploaded nor communicated to us at
We have-
any point of
We have
time.
not taken very serious objection to that for the reason that this is a departmental, I mean, the same
Yes, Lordship.
committee reviewed it.
Yes,
So Article 226 and this appeal, the provision, this is under clause 10
Yes,
of the rules, Guwahati High Court rules.
look,
rule 5A, 5 capital
5A.
A.
Rule 5A of the Guwahati High Court rules. So therefore, that may not be, that
Yes,
may
but
not
my
be a very
submission is
strong
that
point for you to
we
contain.
are not privy to that rejection order also. That was neither
Sure.
communicated nor uploaded.
Mr. Chaudhary would not foreclose your coming to this court on that. ground.
And-
Definitely not.
And regarding that material deviation,
Yes.
as per clause 22, there is no submission from the other side. If there is any material deviation, it should fulfill three conditions. I do not fall into any of those. I have placed it, Lordship. I
Yes,
do not.
yes, but
So-
that was an argument which you made your first argument.
Yes, but there is no response to that. So there is no material
The response is West Bengal versus Patel. According to them, they say that the only way to make it transparent is to scrupulously adhere to the
Yes,
conditions.
very nice, Lordship.
That's all right. That's their argument.
In fact, that clause, my friend is relying on.
Then all the judgment,
We did not respond to that because West Bengal and Silpi have been incorporated in that clause. What it says is this: a substantially responsive bill is one which conforms to all the terms.
yes.
No, no,
Now,
Conditions.
That's right. He has a point where he says that these are no material. See, in this world of cutthroat competition, this takes a background seat. This goes on the back burner. Because more often than not, your experience would tell you that these qualifications, I mean, these points on which a person is non-suited, they are basically, most of the times, they are not very, very important, not very, very material. Now, some certification, something of the kind, I mean, not in all cases would you find a wrong certificate furnished or uploaded by a party. But it is basically that. You're right. I mean, that nitpicking on these aspects of the matter would otherwise in administrative decisions would not be sustainable. This is just nitpicking. That this is not the correct format, this is not done in this process, then in that case, the format of an appeal is always, it's like second appeal where the question of law is formulated.
Lord.
Where in which petition do you find the question of law formulated? That is true for even writ petition under Article 226 of the Constitution.
then nobody will be having a position here.
Difficulty
Yes,
because they would rely on that requirement that,
Yes,
see, any
the
statement.
basic requirements must be there. The basic conditions, the parameters should be there.
All right.
So now that disposal, now there is no response to the clause number 3. And I would not like to argue, in my argument, I have written arguments I have said regarding the essential conditions, non-essential. My case is that I have fulfilled all the conditions. There is no case of non-essential conditions. What
And-
they are asking,
And just strengthening your ground
Lordship.
for our consideration, that especially in such circumstance when all others were rejected, therefore it should have been considered. Anyway, let's see.
and it
So
would have saved, because Coal India should have been happy that they will have to spend 112 less crores.
Price, Mr. Saiki,
They should have been rather supporting me.
your government would be allowing many, many contracts without L1.
But when there's a quality concern is there,
So this is
quality is there. They had quality concern, but they do not have quality check.
In fact,
Yes, submitting a court.
So those scratching back, my back is not scratched. That is the problem.
it's very interesting to hear this. Written notes of submission on behalf of the appellant, that's right, and this is by
All India.
All India, and this is the compilation given by Mr. Saikia.
Lordship.
And other cases they have cited, you just, all will be incorporated.
There are two bits.
we have heard so and so. The judgment is reserved. It was a wonderful experience hearing all of you.
Deeply obliged.
Supplementary list for admission, item 25.
Yes.
May I please, your lordship? My lord, the appellant before my lordships are the, my lord, victim of forced eviction, my lord. My lord, a notice had been issued. My lord, actually it is not a notice, my lord, it is an order issued for the purpose of, my lord, directing us to vacate the land without mentioning any schedule or no any mention in the notice, my lord, that we have enforced upon the forest land. So we should vacate within a period of 7 days, my lord. That is the, my lord, notice put on, into challenge before the learned single judge with an interim, my lord, prayer that the process of eviction should be stayed till the disposal of the writ petition, my lord. Now the learned single judge, my lord, while rejecting our prayer, perhaps, my lord, a limited relief had been granted. My lord may be pleased to find the order is at page 385, my lord. And the relevant part. 402. 402. My lord, it's at 412, my lord.
He has extended the date to
Yes, yes, my lord, coming on, my lord, coming 7th, we are required to vacate, and till then, my lord, we are now, my lord, being allowed without any disturbance. That is the admitted position. Now, my lord, the ground which we have come before my lordship.
Let us see the notice first.
My lord may be pleased to find the notice. It will know, appeal to 251. 146. 146, my lord.
What is the procedure for eviction?
My lord, the
You are obviously an encroacher, but that has to be decided, no?
that has not been decided, my lord. Before that subjective satisfaction, my lord, this is not a notice, my lord. My lord may kindly appreciate, this is an order.
Who appears
You
in the
vacate.
forest department?
My lord.
Yes.
Firstly, my lord, it was their own case that 7 days time was very less. They should be granted another 7 days. That's why, my lord, honorable single judge passed.
That's all right. But now that it has come in appeal before us,
My lord.
we would like him to tell us what is the procedure for
Procedure, my
deciding
lord.
that he's an encroacher.
For that, my lord,
Mr. Saikia is coming. This is an important matter. Mr. Saikia,
Lordship.
this notice is straight away notice to the occupier of the forest
Yes,
land.
Lordship.
Now, there must be some procedure for determining that he is an encroacher, he has entered into the forest.
These are reserve forests. So
That's
in
right.
forest, therefore, there is no such requirement. Even that notice is also not contemplated. If it is a revenue land, we have section 18.
Rule 18.
Rule 18,
Certain
very
rule.
specific. But so far as forest is concerned, nobody can enter it, Lordship. If anybody enters, and it is a criminal offense.
You're not required to go through any
No
procedural.
procedure so far as reserve forest is concerned. This is outrightly a criminal act.
That's right. So can you show that provision of the reserve forest
That's some forest regulation.
as
Yes.
I'm forest
Yes,
regulation?
section 24, Assam Forest Regulation 1891.
24 and 25.
What we propose to do is this.
Lordship.
We will extend the date, no coercive action to be taken by the next date, put in your affidavit.
Lordship, it is like this. Almost 90% people have already left. Hardly
Already
few are left.
So that statement we won't know. Yes, Which
Section 24
of?
Assam Forest Regulation, page 17, if it is the same book. Any person who in a reserve forest trespasses or pastures cattle or permits,
Are you reading section 25?
section 24, Assam Forest Regulation 1891.
Just 24, yes.
Penalties for trespass or damage in reserve forest. Have lots. Then 25 is also there.
One second.
Lot. And 70.
This forest, Doyang Forest, was declared a reserve forest when?
This. I'll give it them a number, but it is more than 50 years.
More than 50 years.
More than
And no claim ever made. No claim of June cultivation or for anything.
No.
Claim ever made
No, they have
under
them.
section 6.
Yes, Lordship, and on top of that, each of the persons are acquiring, they are not landless people. This is a design.
That's something different.
Lordship.
Now we are only concerned with the rights, with the preservation of the reserve forest.
Lordship.
So this was notified some 50 years ago.
Yes, Lord.
All right.
I'll give the right date. Right.
Then
In
every person claiming any right.
Lordship, it is more than 100 years old. Notification of 13/3/1896, that is Doyang, a number
13/3/1896.
1896, and Rangma Reserve Forest is of 13th April 1887. In 93.
So this no claim of anything was made by them.
No.
They are just squatters or.
Just squatters, Lordship, in a very designed way. These people, they have land the property in 3-4 districts. And most of the people are of.
Can you say about this with respect to the appellant?
Yes, Lordship.
How many persons you have noticed? Just for maintaining that,
Yes, Lordship.
record correct.
Yes, Lordship. In fact, when the notice was issued, immediately we have all the videographs, Lordship. 80-90% already brought all their trucks and left the place.
That the appellant has lands elsewhere.
Yes,
How do you say?
from the records, because we have recorded their statements also. Those who have left, it is already in the media.
Did you, that's there, that's
Yes.
there. But did you bring that on record before the learned single judge?
Learned single judge has given us 6 weeks time.
No, no. Did you bring that fact on record before the learned?
My submission before the learned single judge was very clear. None of these people are either flood affected or landless people, number one. None of these people are forest dwellers traditionally. They are damaging the natural habitat and started cultivation of betel nuts and other drug-related materials. These are dens of criminal activities. And this is a designed way of acquiring land in forest. There is a racket going on.
No process in this regulation with respect to removal.
So absolutely no, Lordship. Had it been a revenue village, Lordship, we have a detailed process. So far as a forest land is concerned, that activity is not permitted at all. If somebody occupies a government land, which is a or it's a revenue land, Lordship, there is a detailed process and we have to find out, we have to give notice. And this honorable court also in several cases given us a proper procedure. We also have a procedure.
Do you have one such procedure?
Regarding revenue land?
No, regarding forest land, nothing.
Forest land, nothing. Or if I occupy a revenue land, it is not a criminal offense.
No.
If I occupy a forest land, it is a criminal offense.
That's right. I am referring to, we see that there provision of penalty, criminal penalty is there.
Lordship.
We are on this bar of accrual of forest rights after proclamation until the time inquiry by forest settlement officers.
Lordship.
And then powers of the forest settlement officers, treatment of claims relating to practice of June cultivation. But this whole.
No June cultivation is there, Lordship.
No June cultivation. And they don't claim any right of way, the right of water course to water, nothing.
No, Lord.
Nothing under section 11.
Revenue. In revenue, we have a detailed procedure.
No, we
Under
are
the
talking about this as a
forest.
forest manual.
Lordship. In forest, there is no, and government cannot convert it into a state government, Lordship, does not have the power to convert it into a revenue land also, which they are trying to, in their prayer, if we look at their prayer, they say that demarcate it, whether it is a revenue land or forest land. These are, without any dispute, Lordship, these are forest land. We have clear-cut demarcation with all the coordinates.
Yes,
My lord, our,
it's only been extended 7 days time.
no, my lord, our case is very, my lord, very limited, my lord. We have been branded as a, my lord, enforcers. We have been not even given a single opportunity to place our case before the
But
authority.
how can you place your case when the claim is new one? The forest reserve, you could have claimed only when the time it was being declared a reserve
lord,
forest.
My lord,
Otherwise not.
my lord, what my respectful submission before my lord is that, my lord, it is their case that we are occupying the forest land. But in that forest land, my lord, all the policies of the government for our settlement, for the construction of houses.
Not there.
No, it is there, my lord. They have,
Which provision? Tell us.
no, my lord, the provisions, because they have given us the house allotment, my lord, the government. My lord, may kindly find the allotment orders, my lord, which I have annexed. 300
Allotment
and,
where? In the forest, reserve forest?
yes, my lord,
How
because.
can that be possible?
Because it is possible because, my lord, it was not within the range, my lord. That's why, my lord. Otherwise, it could not have been done. You want please? My lord, kindly turn to page 360.
What is the allotment? Where is the allotment?
My lord, page 360. My lord, may kindly have a look, my lord.
Page 360.
My lord. Allotment certificate. Hereby approval is given for construction of home under the Prime Minister Awas Yojana for the financial year of 2024-2025 to 3 so and so, my lord, 360.
No. But not in the reserve forest.
It is in the, my lord, same area wherein I have been evicted, my lord. Same area, my lord.
Yes.
And, my lord, this house is going to be demolished after 7 days, my lord. That's why, my lord, there was no
We don't find this.
no, my lord, at page 360, my lord.
Page 360 is all approval given for construction.
Yes.
of home.
My lord, this home has already been constructed and we are residing there in, my lord.
But the area must have been demarcated, no?
That is the issue, my lord. That's why, my lord, we have prayed before the learned single judge as well as in the writ petition that there should be a proper, my lord, if for a period of 1 month, if the exercise is halted on, if the demarcation is done or if the writ petition is expeditiously disposed of, my lord, nobody's prejudice will be caused, my lord. My lord, with my very limited knowledge, my lord, regarding the three golden principles of the, my lord, providing interim prayer on stay. As we are in possession, my lord, with peaceful possession without disturbing anything.
Possession, you can't, suppose
My
you,
lord.
you come and build a hut inside the High Court premises, what possession?
No, my lord, that is not the issue. My lord, may kindly say, this is their government. They have allotted the land, my lord, building.
Mr. Advocate General, what?
Lord, you will
Yes,
kindly see
yes.
page 360.
Yes.
My lord.
Where is the indication that the land or the location of the land here? They must have influenced some officers, I do not know, but there is no indication where the home will be located. Hereby approval is given for construction of home under.
Where have
PM.
you brought to the notice of the land single judge that in the forest area you have been allotted land and money for
My
construction?
lord, it is a part of the writ petition we have brought on record.
Where
my
is
lord.
that? Read that statement.
No, that statement,
Then
yes,
how
yes,
can you plead it?
yes, my lord. Statement is there, my lord.
Show us.
My lord.
Yeah, for the contract.
Yes, my lord. Next slide, please. My lord, it is.
We are only, look, we will definitely not do anything to allow you to remain in the forest.
My lord,
But we are only looking at the correct procedure for your eviction.
exactly, my lord.
That's the only thing.
Exactly, my
So
lord.
therefore,
My lord,
unless you are able to tell us
My lord.
or show to us
my lord.
that you are, I mean, legal, you are under legal occupation of the house which was constructed out of government fund and for which the land was earmarked in the reserve forest, I don't think it can be correct.
My lord, it has been earmarked in it is their contention, my lord. It is a
Forget
reserve.
about their
forest.
contention, you have to make out a case, no?
Exactly, my lord. Exactly, my lord. My lord, may kindly turn to page.
It is a penal offense, you have only been asked to move away.
No, my lord, it is a penal offense if I enforced upon the forest land, my lord. They can put me behind the bar.
If you're not in forest land, they're not evicting you.
No, my lord, but they are, my lord, we are
These questions cannot be gone into here, no?
no, my lord, we are the.
Who is going to say, I mean, in this disputed question,
My lord.
question would not lie.
No, dispute has been created by them, my lord.
No.
My lord, may kindly appreciate, my lord. My lord,
Show me that statement that within the forest, it lies
Page-
within
page-
the reserve forest.
page 121, my lord.
Page 121.
My lord. Paragraph 21, my lord. That the petitioners, my lord has got it, my lord. Page 121, my lord.
Yes.
That the petitioner respectfully submit that the eviction proceeding initiated by the are not only arbitrary and lawful, but also in direct violation of the government own sanction and housing welfare scheme under the so and so. Most of the petitioner has been allotted a dwelling unit under the so and so issued by the office of the so and so in connection with so and so. The said letter clearly identifies the petitioner residential site in
Does
the,
this tell us anything?
my lord, in the said villages, my lord, in the same area.
Sir, I mean, where is the statement that this site is located in the reserve forest?
No, my lord, the village wherein we have, my lord, put in our addresses, in our writ petition, my lord, exactly basing on this area, this house is under the village, my lord.
We can't possibly do that.
And my lord,
We
second,
can't give you even a day's relief unless you show to us that you have been allotted that land there and government has
no,
constructed the land.
allotment, land allotment, my lord, admittedly, land allotment is not there.
Whatever,
We do not have,
there
my lord.
cannot be any such settlement even at the instance of the government. If the government has done a wrong thing.
That is,
You can't be rehabilitated in a reserve forest.
but my lord, my respectful submission, my lord, before my lord is dead, at least for such a panel action, the due procedure of law
So that
is,
is what I'm asking.
My
What is the due procedure?
the due procedure of law, my lord, is that the notice for, my lord, placing our case before the authorities.
Before
my
which authority?
Before the forest, the
No,
authority who is,
if it is a reserve forest, then which authority?
the authority who has issued the notice of demolition, my lord, they can carry out a process, my lord. My lord, the due process of law, my lord, which has been, my lord,
The area has been demarcated.
no, my lord, it has been,
Were they given some time to explain that this is not forest land?
no time given, my lord.
No, Mr. AG.
Sir,
They are only looking at.
there is absolutely no doubt on this, no, that this is a forest land. They are also not saying that this is not a forest land.
No, this land, this construction under Manrega, they were made to stay. Is that house there?
Yes.
They have, in fact, lots of 18 have already demolished also.
Not
They have
all.
vacated. Very few are left out.
My lord, the bulldozer action has been done. Now we are.
Bulldozer is permissible there. It is permissible.
Mr.
They are
AG,
not criminals till now.
Mr. AG, the Supreme Court was very strong on such decisions.
No, but Supreme Court has clarified last week that this bulldozer policy is not applicable when somebody
Yeah.
is encroaching land
No,
in a
bulldozer-
government
they are
land
not-
or forest land.
We are not commenting on bulldozer.
Lord, I'm
policy.
sorry.
We are not speaking about bulldozer.
Lord.
policy. We are only asking you to tell us, to satisfy us that no procedure is there because there cannot be any settlement in the forest of forest.
Yes, Lordship, I would like to take your Lordship to one other act, Forest Conservation Act 1980.
What is it?
Same book, section 2.
What does it say?
Restriction on the de-reservation of forest or use of forest land for non-forest purpose. Notwithstanding anything contained in any other law, for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, may order directing that any reserve forest within the meaning of the expression reserve forest in any law for the time being in force in that state or any portion thereof shall cease to be reserved. So suppose we have to allow his construction in a forest land, then we have to de-reserve it for non-forest activities. And
That has not-
that we cannot do without the central government's approval. If any officers have done it of the state government, Lordship, he has totally violated this Forest Conservation Act of 1980.
We are only concerned about the procedure, not
Procedure is
not your
Lordship,
not,
if
not your decision to evict them. That is for sure. You must evict them,
Lordship,
but you must follow the procedure. That's our
Lordship,
concern.
when it is a criminal offense, they should not get any opportunity.
That's all right. If it's a criminal offense, suppose somebody commits an act of felony, you put him to trial. No, you
Yes.
determine.
If suppose somebody comes to my house for theft or dacoity, should I give him a notice?
No, that is
I will first arrest him and put him behind, but then you will see whether he was a theft or not.
Mr. AG, we are only.
His act itself is.
That's true. Mr. AG, we are not at all, even for a second, suggesting that we would in any way
In fact,
approve of,
sorry, I'm sorry, Lord. I'm sorry for interrupting.
we would not approve of any such encroachment, any such use of the reserved forest land. But there has to be some procedure, no?
There is absolutely no procedure. Rather, Forest Department has introduced this procedure of giving 7 days time. This is the procedure they have introduced. In fact, this is not laid down in the.
Then how would they make out their case that no, they are not encroaching?
In fact, the forest officers were at fault because they were sleeping or they were in deep slumber when all this encroachment had taken place. Next in the line will be the forest officials. Why? It is their duty, the rangers, the DFOs.
We would go a long way in supporting your cause, no difficulty.
Lordship.
We are only concerned with the process.
The
That
process
if you
process
take
is totally silent, Lordship.
then
Process is,
in the process is.
that is why
Then
the wisdom of the forest officers.
Simultaneously, Mr. Boya, yes.
Yes. Therefore, to the wisdom of the forest department, 7 days time was given. The wisdom of the honorable learned single judge was that 7 days is short. So they also agreed.
For our satisfaction.
If
we
Lordship gives another 15 days also, I will not object.
For our satisfaction, we are just asking you to do this.
Lordship,
And now we extend the date to another 15 days.
Lordship.
And we ask the concerned officer that he should hear out their case and decide in a 2 pages order that.
Lordship,
this is
that
not-
in my second part, Lordship, I may not be easily agreeing, Lordship, for the simple reason, because when the demarcation is very clear and there is no ambiguity, no dispute, in that case, whether an opportunity should be given, this will be a futile exercise. The second part. Till now, before, suppose, Lordship, let them
Exercise.
prove it. Let them prove it with a single document that they have some some title or possessory right over that land. Before this, Honorable, I will agree to that also.
See, I'll tell you what.
If the forest officer
Mr.
given them that
We have,
opportunity,
we have seen that drive by the state government. It's absolutely laudable. There's no difficulty. We are concerned with one thing, we are repeating. Please don't
Lordship.
mind, we are repeating. There is a law everywhere, in every state, in every town. It is prevention of encroachment of government land. So assuming that government land and there is a squatter, but even then, he has to be subjected to such notice. That is our concern, because this is the law
I
which we
have,
have been practicing.
I
always.
am totally on the same page with this honorable court.
Yes.
Totally the state government. So far as revenue, Lordship, we have a detailed procedure. So far as forest, there is no procedure laid down. In spite of them, we have given them 7 days time. Thereafter, the honorable court said that 7 more days, we agreed to that, we considered. The concession was from the other side as well as from us, that 7 days is too short a time. Then we agreed, if Lordship is pleased to look at that order, that
You have-
concession is there
you have seen that.
from the petitioner's side. So we also, even today, Lordship gives them another 7 days. I will agree. But to verify their authenticity or their right over that land, that exercise, in my humble submission,
That
may not be called for.
that may, open the Pandora's box, I understand. But then give them one opportunity of going and talking to the concerned forest official.
Lordship, if they can satisfy this honorable court that they have some right over the forest land, I am going to consider everything on behalf of the state. In the writ petition also, they have failed to put any such document.
Do one thing, we are only concerned with implementation of the Supreme Court judgment. Now, we are only asking you not to take any coercive step for another 7 days. You just put in your affidavit, we hear you on 14th.
Lordship,
Is that correct?
Lordship, it's no difficult.
Because in that case, it'll.
Another 7 days they will give.
It'll set the law in motion.
Lordship,
And then these kind of complaints would not keep coming.
definitely, Lordship. And if whatever they will place before the forest officer, let them place it before this honorable court.
That's all right.
Let them place it.
Justified.
Lordship.
So we extended by another 15 days, but before that we will decide this appeal.
Lordship. And Lordship may be pleased to pass a direction to them also.
Yes, yes.
So whatever they want to place before the forest officer, they can place it before this honorable court.
Yes. But that is the outer limit. You will be evicted by force.
My lord, highly obliged, my lord.
You see, Mr. Advocate General, you must take that care, especially in today's, world, when this kind of litigation travels up to the Supreme Court.
Lordship.
And the personal rights of a person, of
Lord.
course, he has no right to stay there in the reserve forest. But that should not be whittled down to nothing. I mean, like, just tell them to get away.
No.
Now, unless they show, that's right, it cannot be decided here. They would, but you have to create a body, no?
Lord.
You have to create a body which will
Yes.
hear the complaints.
At least
And
we
then
have
they will
started.
decide it within 7 days. You have started,
We
that's
have
a very, very good work.
Total 29 lakhs bighas of land are in this kind of occupation. And during the course of last 1.5 months, we have cleared more than 1 lakh bighas. But we have a long way to go.
No, we will not come in the way.
Lord.
We assure you that we
Deeply
will not
obliged.
come in the way.
Lord.
But
No, we'll definitely.
we have
If the
a-
procedure is set, Lordship, that will be
we have
easier for us.
We have our responsibility towards citizens also. So we will not come in your way of getting the forest land evicted. Absolutely not. Don't
Lord.
be under this
Lord.
apprehension. We will be the first one to say that you please take action.
In fact, there are PILs pending on that line. Before this honorable court, that government lands are enclosed and government is not doing anything. That PIL also is a live PIL, Lordship. Well.
Take it.
Government land, I did vote on. Ma'am, I was trying to.
We have heard Sri A.R. Guyan, learned advocate for the Poland, and the learned advocate general for the state. About 59 persons came up before this court, challenging issuance of notices to them dated 24/7/2025, asking them to vacate their land within 7 days. alleging that such an action of the respondents is in contravention to the provisions contained in section 18(2) of the Assam Land and Revenue Regulation 1886 and the Assam Land Policy 2019, as also the guidelines of the Supreme Court in the order dated 13/11/2024, passed in WP(C) 295 of 2020. The claim of such persons before the learned single judge was that they are in possession of the land in question since the times of their forefathers, and such notice has been served upon them without any specific demarcation as to whether the land in question, said to be in the illegal occupation of the appellant/writ petitioners, is a revenue land or a forest land. It was thus prayed that in the absence of any such clear demarcation, the notices be treated as non-est. The learned single judge, after considering the rival submissions of the parties, found that providing only 7 days window to the appellant/writ petitioners to vacate the land over which they have been residing for a long number of years, as claimed by them, would be too less, and therefore extended the time for clearing the forest land till 7/8/2025. However, by the impugned order, the appellants/writ petitioners were directed to vacate the forest land, and the state also was permitted to take steps for eviction and conservation of the forest land. This order was made applicable only to the writ petitioners/the appellants. The contention of the appellants here in this appeal is that no procedure has been followed for their eviction from the forest land. Their eviction from their houses, which were allocated to them under some scheme of the government in the past. The learned Advocate General, however, stoutly contested the aforementioned submissions and stated that give us the page of the notice.
140, 146.
Any page 161 or it starts from 160,
What have I said?
161.
Aforementioned submissions and stated that the appellants are encroachers in the reserved forest of Doyang. He has further submitted that after the notification of a forest to be converted into a reserved forest and its proclamation by the concerned officer, any non-forest activity in the reserved forest would be a criminal offense for which penalty has been provided under the Assam Forest Regulation 1891. In such reserved forests, any clearance by an encroacher or an act of setting fire to any leaves or fire burning which would endanger such forest, or of kindling, keeping or carrying any fire except at such seasons and in such manner as forest officer is specifically empowered in this behalf, may from time to time notify, or felling, cutting, girdling, marking, or injuring by fire or otherwise any tree, or quarrying stone, or burning charcoal, or clearing or breaking up any land for cultivation would be prohibited. Would be prohibited. He has further submitted that approximately 29, approximately how many bighas of land you said?
In this.
In Assam,
Huh?
20 lakhs, 29 lakhs, more than 29 lakhs bighas of land
He has
in various reserve
He
forests.
has further submitted that approximately 29,000 bighas of land in the reserved forests in the state of Assam have been cleared,
No, not clear.
Clear.
And more than 1 lakh has been cleared.
are in 29 lakhs bighas of land in forest areas in the entire state of Assam is infested with encroachers. And with the state drive of removing such forest area of any encroachment, 1 lakh bigha,
More than 1 bigha,
more than 1 lakh bigha has been cleared.
including this one, Lordship.
It is in the same process of clearing the encroachment from the forest land that such notices have been issued to the encroachers. The Land Council for the petitioner, however, submits that they are residing in the houses constructed long time ago with the government funds and over the allocated land. But such statements are not supported by any documentary proof. In fact, as we have been informed, the Doyang Reserve Forest was notified as such about 100 years ago. About 100 years ago. And never in the past, the appellants had made any claim for settlement or for their right for June cultivation. Or else it would have been decided by the forest authorities. The learned Advocate General has further contended that none of the appellants are either flood affected or landless or forest dwellers. They are squatters and encroachers who, by their continuous illegal activities, have been damaging the natural habitat of such reserved forests. He has gone to the extent of saying that the encroachment is a designed way to capture the forest land, which cannot be permitted. no procedure has been delineated for removal of encroachment from forest land only for the reason that a reserve forest, that there could be no settlement or no other activity except forest activity in a reserved forest. Thereby leading to the presumption that any person residing in the demarcated reserved forest is an encroacher. Stop. We have already noted that except for bold statements of the appellants that they are residing in houses constructed over areas which do not fall in the forest, in the reserved forest area, comma, no proof for such a statement has been given. Precisely for this reason, the learned single judge thought it best to provide them another 7 days for evicting, for clearing the reserved forest area, failing which the state government would have been within their rights and also under its obligation to have the forest area cleared. However, in order to satisfy us that the appellants are not being forcefully evicted, are not being forcefully and illegally evicted from their place of residence, comma, we permit the appellants to bring on record any document of their being allocated land in the reserved forest area for construction of houses. For the aforesaid purpose, we extend the time for them to clear the forest area for another 10 days, comma, to be counted from today. The learned advocate general shall also ensure that an affidavit is filed, ensure that a positive statement is made by way of an affidavit of a responsible forest official, affidavit by a responsible forest official that the appellants have been residing in the reserved forest area without any entitlement and are liable to be evicted forthwith. Let this matter come up for consideration on, give a date, within the 14th, on 14th of August. Stop. Till such time, no coercive steps shall be taken
Against the appellants.
against the appellant.
My lord, can it be 15 days?
No,
10 days? My lord, what has happened?
even a day, allowing an encroacher to stay in the reserved forest area even for a day would be bad. We are only concerned with the procedure. We want an affidavit from them that you are there in the demarcated area. ऊपर में और एक click ना paragraph at the appropriate place. Stop. The learned advocate general has further submitted that the forest area has been demarcated and only such persons have been issued notices who are found to be residing in such demarcated area. For the eviction of encroachers on the revenue land of the state, a procedure has been delineated. But considering the fact that no activity is permissible in the reserved forest area, comma, no such a specific procedure is prescribed in the Assam Forest Regulation 1891.
Deeply obliged.
Obliged. My lord, second item is also same, you know.
This is the same.
Only number of appellant is less, my lord.
And the reserve forest is different.
This is which reserve
Number.
forest? No, both the Doyang and what is the name?
Number.
And Nambor. Like the Doyang and Nambor Forest Reserve Forest area. Both the appeals have been taken up together.
My. Obliged, my lord, deeply.
Mr. Bhuya, not a day more.
My
Not
lord, I
a day
am,
more.
my
You
lord,
don't have a right.
my lord, I am very obliged, my lord, because there are some pregnant women and children are there, my lord. That is the
See,
issue, my lord.
that compassion is one thing,
My lord.
but you can't possibly destroy the
Honest, my lord.
ecological, balance.
I can
You
understand.
can't possibly do that, and we shall be the last persons to approve of it.
No.
We are just ensuring that you get an opportunity of explaining your cause, not if there is no procedure prescribed, at least before us.
My lord.
And if we find that your claim is bad, we'll ask you to evict within 2 days or 3 days. because
Mal.
Already you have got a time.
My lord.
Utilize this time for packing up.
And if you have. My lord.
Highly
Obliged,
Yes.
highly obliged.
Item 27.
May I please, your lordship?
Yes,
My lord, this matter regarding compassionate appointment, my lord.
yes.
Procedure, my lord, is not followed, my lord. This is the case, my lord. Ultimately, my lord, this is to be considered by the DLC or SLC, my lord. As per judgment and order passed by this honorable court, my lord, DLC concerned DLC of the district recommended his name, my lord. In the meantime, my lord, when his claim for further consideration and or approval by the SLC, my lord, my lord, circular has come, my lord, abolishing the entire scheme of compassionate appointment, my lord.
And even if it had not come, we would not have permitted you because 16 years have passed by. Your rights, assuming for the inaction of the authorities.
Yes.
But the necessity of providing you that succor, that gets diluted. Why do we do it now?
This aspect is there, my lord, but one, my lord, a group of cases filed on the same ground, my lord, and this, my lord, learned,
However, we are not going to permit this.
yes, my lord. Learned single judge,
Now,
my lord,
you may not be the person in need of government employment on compassionate ground. For 16 years you have survived and you have survived well.
not my lord, on loan, my lord, and etc., my lord, with the hope of compassionate appointment, my lord. Ultimately, my lord, with due respect, my lord, I may submit, my lord, one job is not found, my lord, nobody will die, my lord. There are many people, my lord, living, my lord, without government
That
job.
would
my
be unfair to persons who are desirous of entering into government service. This is just a backdoor appointment.
Only, my lord, the thing is that, my lord, here, this case is, my lord, a little bit different, my lord, to support one judgment passed by this honorable, because, my lord, this honorable court already,
Anyway, you know the result, therefore don't waste your
my lord,
lung power
only,
now.
my lord, ceremoniously and
Keep it reserved for
unceremoniously.
some other day.
Yes, my lord.
Mr.
Because-
Bhuya, you keep it reserved for some other day, all your energies. Why waste here? 16 years, we are not going to
The
interfere.
only thing is that, my lord, because one order was passed, my lord, it always, my lord, ball is in their court still, my lord.
We
In
have
the
heard
SLC,
Sri-
they may
We have
reject
heard
it.
Sri A.M. Bhuya, learned advocate for the opponent, and Mr. B. Kaushik for the respondent. The judgment under challenge is dated so and so, passed by a learned single judge of this court in WPC number so and so.
Then, my lord, I may be, my lord, allowed to draw, my lord.
After some arguments, Mr. A.M. Bhuya, learned advocate, seeks permission to withdraw this plea. Dismissed as withdrawn.
Obliged.
Daily list for hearing. Item 2.
Yes. Yes.
It is a lot. I'm appearing in this case, my learned friend. I don't know whether it will be an academic, because I have seen in this case, it is regarding about payment of bonus, which was amended
The
in
amendment.
2015. So it has been challenged before various high courts. Ultimately went to the Supreme Court. Supreme Court says the parents high court will decide. Ultimately, Patna High Court has decided.
Patna High Court has
Yes,
decided.
it has gone against. He's saying that These are welfare legislation, so we are not interfering with. Retrospective effect of clause 213 and 12.
And we have
213
that judgment, so we concluded.
Yeah, no, that's why. What has happened, my not only this, I had an arguable case, but the problem here lies, there's a weak point from our side. Problem is there are about 263 gardens where we are representing. Representing, we are the Indian Tea Association registered on the Companies Act. My lord, 47 gardens, when the writ petition was pending, 47 gardens has already paid. Kindly see the operative portion of the order of the Patna Act. See at para 12. No. Which? SCC. SCC. I think this is an SCC, my lord. Sorry. Is reported. SCC online. Paragraph 12. Yes, yes, take it out. Take it now. No, no, don't give it. One second. Kindly see the judgment of the Supreme Court.
Remanding.
Yeah, remanding. And what it says at para 27. 27. He says that the High Court, parent High Court will decide on each
So
fact.
we're deciding it now. We are aware of it.
No, that's right, that's right. But we have a problem, my lord. That's why I'm saying before going to it. I have seen some affidavit has been filed by Assam Sah Mazdoor Union saying that we represent about 238 gardens, 253 gardens. We are the registered under Companies Act is a tea association. We ventilate all the grievances, they are the members. 67 gardens already paid.
Paid.
67 gardens already paid. 147 remains. This is what I don't know, my lord, whether I can, whether it's academic or already paid. So this is the only one area where it will be difficult.
No, I don't.
They have paid already 67 gardens and I have to bring notice to the court. Because that's their affidavit they have stated. But otherwise, my lord, I don't know whether your lordship, I could have argued in this case, my lord. Acceptance is different, my lord. 213 and 12. We are not on the amendment of 2000 16.
The only ground which is worth challenging was the retrospectivity.
Right,
That is-
that's,
that is-
that's correct. That's the
and
only
that's
ground.
because of the current financial year. Most of the companies would have paid
Yes, right.
before the
Right.
notification.
Right,
the
that's-
only-
My lord, that was our case. I thought of projecting, but I thought I will tell you lordship, this is the situation. Because I thought because the problem here is you have to see 4, 5 and 6. Already as your lordship has indicated, already profit and loss already computed for the all gross profit, my lord. And they said from 1/4/2014, we have to pay till the financial year of 2015. And there is
And
absolutely.
the financial year computation is of 8 months.
My lord, we'll see. I don't know, kindly see. 1 second. My lord,
Which
please
other
find-
court has decided it?
No, that's what I try to find out.
That's
I think
if I may, there's a.
Madras had still.
Madras has decided.
Decided.
Kerala
Madras has
decided?
decided. I've.
Karnataka pending.
The constitutionality would have been upheld. No?
Yes. Because, my lord, I have gone to the provision what your lordship has indicated that I thought of arguing because accounting here, I have seen what is the schedule, second schedule is mentioned,
Doesn't matter. No?
the computation of income, how it has been a profit and losses. But the only here,
That was the Madras High Court decision.
We're not going into such a detailed journey. Considering for such detail.
only difficulty here is a tea industry, my lord, tea oriented industry.
That's right.
Labor industry. And the problem here is that your lordship will look into it. Here, what they have done, my lord, by virtue of 213, their particular is have been enhanced from 10,000 to 21,000. Now, where we decided, my lord, we have already paid. Now, some of the employees have come within the bracket of more than 10,000. Again, this is the what we have calculated. We have paid.
Yes.
This is again, everything has to be reopened, my lord. Everything has to be reopened.
You should have done that before. Now so many years, 10 years have passed by.
No, this has been put to challenge in 2016.
So otherwise, from the
2016.
succeeding year, you have been paying.
I have been paying. There is
So
absolutely,
this amount also, it has to be paid.
this is what, my lord,
The petitioner. We have heard Sri D. Das, learned senior advocate, assisted by MS N. Upadhyay, learned advocate for the petitioners, and Mr. R. K. Dev Chaudhary, Deputy Solicitor General of India, Deputy SGI.
Yes, Lordship.
Deputy Solicitor General of India
For 1 and 2, Lordship.
for response number 1 and 2, and MSA Bhattacharya and Mr. P. Kalita for response number 5. The petitioner, a society registered under the provisions of West Bengal Society Registration Act 1961, which is a pioneer and oldest association of tea producers in India, has challenged the constitutional validity of the payment of bonus bracket Amendment Act 2015, which received the assent of the President on 31st of December 2015, but was published in the Gazette of India on 1st of January 2016. The primary challenge is to the provision of section 1 bracket 2, which provides that the amending act shall be deemed to have come into force on 1st of April 2014. As a result of such amendment, 2 changes have been made in the Payment of Bonus Act 1965. Namely, Roman 1. In section 2 bracket 13, which defines the expression employee, the ceiling on salary or wages has been enhanced from 10,000 to 21 rupees 10,000 to rupees 21,000. And the other two is an amendment in section 12 of the Act, by which the amount in question has been raised from 3,500 to 7,000, or the minimum wage for the scheduled employment as fixed by the government, whichever is higher. Mr. Das, learned senior advocate,
Yes, sir.
submits that by virtue of the provision contained in section 19B, the time limit for payment of bonus is 8 months from the closing of the accounting year, correct? The time limit for payment of bonus for the accounting year which ended on 31st of March 2015 would be 8 months from the closing of the accounting year, which would fall on 30th of November 2015. The expression accounting year has been defined in section 2. It has further been submitted that section 2 bracket 1 bracket Roman 3 bracket A defines the expression within force in any other case for clause not falling in clause 1 and 2 as the year commencing on the first day of April. The contention therefore is that because of the retrospective amendment, the financial liability of the employer would have to be recomputed and would have to be enhanced in respect of a period where perhaps a deposit would already have been made in compliance of the provisions of section 19B, even before the assent of the president was received on 31st of December 2015. On that ground, it has been urged that the retrospective amendment is arbitrary and also violative of Article 14 for the reason that it casts a liability on the employer which was hitherto not known to him. It would be relevant here in this context to state that said amendment had been challenged in various high courts on similar grounds, namely on the retrospectivity as also on the validity of linkage to the minimum wages in regard to calculation of bonus. To avoid duplicity of judgments, transfer petitions were filed in the original civil jurisdiction of the Supreme Court of India, seeking withdrawal of all such writ petitions in different courts to the Supreme Court. However, such a prayer was rejected. Rejected. Giving liberty to the parties to request the respective high courts for expeditious hearing and disposal of the pending writ petitions. The high courts were also asked to proceed with the matter expeditiously, assigning such cases a reasonable priority. The learned counsel for the learned senior advocate for the Mr. Das, learned senior advocate, has fairly submitted that two of the high courts have decided the constitutionality and upheld the same. And but for the fiscal responsibility cast upon the companies, there would be no other matter on which such or on which the constitutionality of the amendment could be questioned. He has particularly referred to the judgment delivered by Madras High Court on 12/4/2024 and by Patna High Court on 25/9/2023. 25/9/2023. With respect to the retrospectivity of the amending act, the Patna High Court relied upon the judgment of the Supreme Court in Jayam and Company versus Assistant Commissioner and another 2016, 15 SCC 125, wherein it was held that even with respect to fiscal legislation, the competent legislature has power to make provisions retrospectively. A law cannot be held to be unreasonable merely because it operates retrospectively. The unreasonability must lie in some other additional factors. The retrospective operation of a fiscal statute would have to be found to be unduly oppressive and confiscatory before it can be held to be unreasonable as to violate constitutional norms. with respect to the degree of unforeseen or unforeseeable financial burden because of retrospective legislation. How have I begun this sentence? See? Sentence, how have I begun? What have I said? No. How have I begun? Sentence padhiye. With respect to, all right, with respect to the degree of unforeseen or unforeseeable financial burden because of such retrospective legislation. It was held that that could be a factor which might be required to be looked into. Before dealing with the aforementioned issue, we deem it appropriate to state that there is practically no challenge to the legislative competence of the Union of India in bringing about the amendment. The only question is whether it could be said to be unreasonable or violative of any provisions of the Constitution. Times without number, the Supreme Court has held that in any challenge to constitutional validity of any provision in a statute, the court exercising the power of judicial review must remain conscious to the limitations of judicial intervention, especially in matters relating to legitimacy of economic and fiscal legislation. But even otherwise, with the amendment, the recomputation of bonus and the difference which will have to be borne by the companies would only relate to financial year 2014 and 15, which cannot by any stretch of imagination be said to be oppressive or absolutely unreasonable. Next, the Payment of Bonus Act provides for payment of bonus on the basis of profit or on the basis of production or productivity and matters connected therewith. The amendment only brings in its train more employees under the beneficial legislation. And it also enhances the limit of salary or wage on which bonus would be paid. We reiterate that the retrospective operation is only for one financial year. and the benefits of this legislation outweighs the difficulties faced by companies which would have already completed their part of the obligation of paying bonus to their employees. This, in our estimation, is not unreasonable, nor does it create any unforeseen, or nor does it create huge burden, howsoever big the company is in terms of its enlistment of labor. Enlistment of labor. Mr. Das, learned senior advocate, has also very fairly stated that maximum number of the tea garden owners, the constituent
47, we already, 47 of our members. Yes.
What is it?
78 gardens.
The association is of how many
No,
gardens?
my lord, this is paid, but association 47. There are other association, PAI, these are not concerned.
Yes.
47, my, 47 paid.
Mr. Das, learned senior advocate, has also informed us that 47 of the tea garden owners who are the constituents of the association have already paid theirs. Have already paid the bonus in terms of the amended act.
Yes, correct.
And tea growers slash garden owners in other establishments also have done their part in recomputing the bonus amount and paying the same to the employees. Thus, in the absence of any challenge to the competence of the parliament in enacting such amendment, and the amendment not in any manner being unreasonable or violative of any one of the fundamental rights under the Constitution, ought not to be interfered in. Thus, we dismiss this petition. Has been without merits.
Strictly obliged.
Item number 6.
My lords, in all fairness, I may not be able to do justice to my brief in the time available. So I would seek your indulgence to take up the matter on either 8th or 11th, 12th or 13th, any date, but early or not.
It has to go after 15th
In that
For
case,
the-
19th, your lordship.
for the heavy board that we have.
I understand. I need at least, we need maybe one session, your lordship, or maybe slightly less than that. So maybe
It's a
19th.
contempt petition.
It's a,
The direction has
It's-
already been
it's-
complied with within the time granted. by
I
the-
seriously am going to
My
dispute
friend, my
that,
lord.
your lord.
No, what was
Yeah,
the order?
I can, yeah, lordship in 2000.
No, if you're in any difficulty.
Not
you
at all,
may
your
not
lordship. I am ready, your lordship. Only I would not like to. You have had a long day, your lordship. So this will go on for. So I was just, let me introduce the matter, your
Yes.
lordship, very briefly, then you can. I'll not go to the brief, I'll just tell you what it is.
Yes.
Your lordship, in 2013, the Assam highway was, the building of the Assam highway, Arunachal highway. They started building. So there was a segment in that of 31 kilometers, which was bypassed. And the villagers staying on that 31 kilometers came to in PIL in 2013 to the Honorable High Court. The Honorable High Court heard them, and the state was supporting them initially, but later on it supported North, whose stand was that let the original alignment be abandoned and we make the road on the new alignment. The contractor was also interested and he also held that the new alignment is better. At that stage, the Honorable High Court heard arguments from all the petitioners. In fact,
Was that general litigation or PIL?
PIL, Your Lordship. In fact, two PILs had been merged. In that, Your Lordship, the Honorable High Court felt that since already compensations have been collected and deposited, as well as originally the state had acquired land on the original alignment, that is 31 kilometers. But as the North as well as the contractor held that the alternative alignment, which was 15.4 kilometers, was technically better. It allowed higher speeds, less culverts, and on the scientific basis, High Court gave a very interesting ruling. It balanced. It said that the National Highway Authority's contract, the contractor will make the 15.4 kilometers, so he is permitted to change the alignment. However, simultaneously, since the state government originally was desirous of making the highway, that is the two-lane along the old BRO road, which was the 31 kilometers, the state was also on record as having given affidavit that the survey was also done on the original alignment. So the Honorable High Court said that simultaneously, as the highway is made as per the contract on the new alignment, 15 point something kilometers, the state must make a similar road as per its own submissions to North earlier on the old alignment. Now, this was the status still.
So they have constructed the bridge or road, but with a different alignment.
Your Lordship, that's not my problem. The new alignment is not the issue here.
Then,
in the old alignment, then what happened in around 2015?
now tell me one thing, what can be done now?
Your Lordship, a lot can be done now because the little has actually been done.
As a damage,
Lordship,
in your
Lordship,
estimation, just a minute, Mr. Kashyap. If the damage is done, according to you, so far so good. But as a citizen, would you say that this road should be demolished, destroyed and another road?
Not my case at all, Your Lordship. I want the road.
Then?
I want, see, Lordship, maybe I have not explained nicely. Lordship.
No, you have. Without looking at the papers, you're telling me everything. But tell me what is the issue now and what can be done?
Lordship, the issue now is the old alignment. Honorable High Court's ruling was make a two-lane highway as per the submissions you have already made. What they did is they waited till 2017. All the time we were following up with them. We went to in contempt around 2015. We came to this honorable court. We were told, oh no, things are going, this is premature. So we withdrew. Then, Your Lordship, on 2017, they gave us a note saying there was a confusion in the old alignment and new alignment. Now everything is resolved. We are starting work on both the alignments. The new alignment was made in, I think, 21, 23, something around that time. But the old alignment, 2017, the acquisition order for new alignment came. I have nothing to do with new alignment here, Your Lordship. That's the important point. Old alignment in 2020, they come up with a notification, which is the impugned order here. And that notification says, we are going to do out of the 31 kilometers, 15 point something kilometers as PMGSY road. Now, Lordship, had it not been so tragic, it would have been a civil engineering humor because the existing road is 4.9 meters and the road they are making by upgrading it to PMGSY is 3.75 meters. That in itself is an impossible task. Secondly, Your Lordship, the facts. Sorry. Lordship, I'll have.
Mr. Kashyap, on some other day.
Lordship, 19th if possible, or 20th.
All right, on twen- as prayed for on behalf, as prayed for by
I
Mr.
have no objection.
Mr. Kashyap. As prayed for by Mr. A. Kashyap, learned advocate. Re-notify. So and so date. You have no problem for
I
20?
have no objection.
Lordship may be fixed date.
You are BD Goswami.
I'm Goswami.
We are trying, I'm trying to remember your names. No?
I got a long name.
Correct names.
With the initials, it's good. Why not?
But
Otherwise, I have got a very
I
long
don't
name.
feel comfortable addressing advocates as Mr. Counsel. Unless I call out their names, I don't feel comfortable. That's why I get these, names.
That's nice. That's nice.
Great, great.
US president used to keep, nowadays, of course, there are these displays, but he used to keep physical photographs of the people whom he was supposed to meet that day and call them all by first name.
19. 19.
So 19th, you're like
20th.
20th.
20th is a hearing day, no?
Wait.
Wednesday. Now, let's keep it on a hearing day.
Whatever, 19th or 20th,
19th.
whatever,
19.
19th. Much
All right.
obliged, Allah.
Item 9 and 10.
This is what. Item number 13 to 16.
No.
No,
9 to 10.
9 and 10.
9 and 10. All right, yes.
Lordship, the issue involved here is, Lordship, whether a member of the disciplined force, Lordship, who has been absent from duty for 1,782 days is pardonable and he deserves reinstatement, Lordship.
That's pardonable.
Whether it is pardonable, because
The question is whether it is pardonable.
because the single judge has allowed the writ petition asking for reinstatement, basically on the two grounds that he has been punished earlier for a proceeding for 89 days. So he could not have been proceeded against, again, in virtue of section 97 of the Assam Rifle Act. And the other Lordship issue is that since it was decided by the summary Assam Rifle Court, which requires no confirmation, whether we could have reviewed the order and asked for fresh trial, Lordship.
So let's see how did it go.
Lordship. That aspect, Lordship will find it,
Let's see the impugned judgment.
Lordship. Basically, the discussion and finding will, Lordship will find at page 73,
Just a minute. Let's have some idea of the
Lordship.
text. Give us 2 minutes.
Lordship.
Please take your seat. We'll call upon you. This for you need. Let's see Assam Rifles Act 26B, whether there is a provision.
Lordship.
Yes.
Lordship may take the regulation section.
Assam Rifles Act or regulation? We would like to see section 26B of the act and 97 and 136 as well.
Lordship.
Let's see 26B.
Wait there.
What is 97?
Right. So,
Yes.
Lordship. Lordship, this finding is Lordship has gone through paragraphs, Lordship.
What's that 340 proceeding against the officer?
Lordship. Oh, that is pending, Lordship. Now, Lordship, that he has been punished for 89 days. That is absolutely, Lordship, with all respect, perverse, because Lordship may kindly come to the page.
You appear for the respondent, my lord.
Page 27, Lordship. By which the learned single judge draw conclusion he has been punished with 89 days. That was in respect of Pramod Kumar Yadav, not he. Two names are there on that. Lordship, page 27 of the appeal memo.
Page 27 of appeal memo.
Appeal memo. There are two names.
Before the court.
One is Chandrasekhar, that is the respondent. He has been severe reprimanded only and forfeiture of pay. And the second name is Pramod Kumar Yadav. That is, he has been punished for rigorous imprisonment for 89 days, not Chandrasekhar, Lordship. So this finding is wrong.
No, but
Punishment
was
is
it was brought to the notice of the court?
No, it was not
Then.
overlooked.
Then what?
This communication has been overlooked. Neither the appellant nor the respondent brought this to the notice of the court. So far as Lordship, this false statement, Lordship,
You're not challenged that part of the judgment. No?
not Lordship, but that Lordship, that is also
Any proceeding under 340, that is a different forum, not this appeal.
Lordship. That's true. Now, so far as that finding is concerned, Lordship, the petitioner himself admitted he has been punished earlier by Assam Rifle.
That's Assam Rifle. I mean, if it is by SARC,
Lordship.
then perhaps section 137 comes in the way of your
Lordship.
again.
Lordship. Lordship, 137. Yes, Lordship, 137. Even the SARC can be put before the request to be put before the higher officer. May I read 137, Lordship? And 137 has to be read along with Rule 173(2), Sub-Rule 2. One 170 also speaks about review.
37 first.
137. The proceeding of every summary Assam Rifle Court shall without delay be forwarded to the officer not below the rank of Deputy Inspector General within whose command the trial has held, or to the prescribed officer, and such officer or the Director General or any officer empowered by him in this way may, for reason based on merits of the case but not merely on technical grounds, set aside the proceeding or reduce the sentence or any other sentence which the court might have passed. Lordship. Now, Lordship may kindly come to rule, Lordship.
Where do we find the rules?
I have given messages, Lordship.
Yes, which
170.
117.
170. Review of proceedings. Page 231, Lordship. May I read, Lordship? The proceedings of a summary Assam Rifle Court shall immediately on promulgation be forwarded through the law officer, chief law officer or a law officer nominated by him to the Deputy Inspector General or Inspector General under whom the accused may have been serving. So that at least some provision is there for review, Lordship. And that has to be read along with Lordship 173 Sub-Rule 2. A confirming authority, or in the case of a summary Assam Rifle Court, the court shall direct that the sentence of imprisonment shall be undergone by confinement either in a civil prison or in a forced custody. Such direction may be varied by any superior officer.
No.
So they can vary, Lordship.
No. Tell me one. Now, this was this period of 89 days forced custody
Lordship.
was under section 26B.
Lordship.
Is that
Now, he was never in custody. He was never in custody. For him, the punishment was severe reprimand and forfeiture of pay only. Lordship, can you come to page 27 again.
But all these facts you have not disputed before the learned single judge.
Lordship, that was not brought into the.
Then
Mistakenly, it was,
go for review. We can't do anything. In fact, you go for review and then you ask him can it go. The lead counsel for, what is his name? Mr. B. Chakravarti, learned central government.
CGC, Lordship.
Your central government council. Mr. B. Chakravarti, learned central government council. While canvassing the grounds of appeal, submitted that the learned single judge misconstrued that the respondent was subjected to forced custody for 89 days for overstepping his leave for 1789 days.
1782.
17 or whatever number of days. What have I said? What have I said? I just forgot the link.
It's also that the respondent was subjected to forced custody of 89 days for overstepping his leave for 170.
Under section 26B of which act?
Assam Rifles.
Assam Rifles Act. No, in fact, the respondent was only subjected to a reprimand. He has further submitted that there was some confusion with respect to another constable / sepoy for whom the order of forced custody was passed. In that view of the matter, it will be more appropriate for
Lordship, may remind them, I think.
no, it will be more appropriate for the appellant, Union of India, to approach the learned single judge under review. There's not hopes and trusts that the learned single judge, subject to the law of limitation, subject to the law of limitation. The present appeal is disposed of with the aforementioned observation. That's your only ground. Otherwise, section 97 comes in your way.
No.
This would be a second trial.
Lordship.
That's the only thing you can do.
In fact, second trial was also not held. Jesus dispensed with a notice that there is no necessity of a second trial also.
No, yeah, the full summary, I have the record. I have the record, Lordship.
Really obliged.
The contempt petition shall also be taken up by the learned single judge in case the review succeeds. How many matters left?
One series is there 13, 14, 15.
Who appears in item number 13 to 16? Huh? Mr. Chaudhary, you are appearing.
Yes.
Hear you on some other day.
Not.
Something for anything, sir, right?
I think it is covered by Lordship's earlier judgment.
Covered. Then we finish it off. If it is covered, we finish it.
But the only difficulty, my lord, we have filed a review application against that judgment.
So what?
And then
Review will take his own course.
We will take it from.
Judgment.
I think this will be the order
Precisely.
covered by student so that.
Yes. My lord, that is 2024, 5 GLT,
2025.
2024, 5 GLT, 689. Paragraph, my lord, 168 to 172. My lord, government servants are being paid fixed salary, my lord. 12,000 rupees.
All right, dispose. You have to brothers.
criminal इनके पास है, हमारे पास नहीं है।
इनको देने के लिए दिया।
कल की दोस्त बात, हाँ, तो मेरे पास आया, हाँ, मेरे पास नहीं चली थी। मेरे पास नहीं चली थी। तो जगह थी, भैया, इधर ही है।
Then who appears in item number 17?
Deep level.
Who appears in item number?
Item 17.
Mr. Chaudhary, you just ask your junior to give the appearance slips in all these matters.
Milord.
You're appearing, you have appeared in all 4 matters, no?
Yes.
13, 14, 15.
I'll give Milord. I am appearing in 13, 14 and 16. I am not in 15, Milord.
13, 14,
14 and 16.
16. Who appears in 15?
My learned friend.
Is this appears?
Yes.
In terms of the judgment which you have shown. All right. 17.
79, 18 for reference number 1 to 4, my lord.
Time for 1.
Found by-
Which, for the respondents, give your slip, no?
Yes.
Appearance slip should be given.
Yeah.
Petitioner.
Item number 17, call for.
Item 17.
17, madam.
Petitioner side.
Petition is
Seeking adjournment, I think.
adjournment.
Nobody appears on behalf of the petitioner. The counsel for the respondent, however, is present. This matter for 3 weeks.
4-9. Item 18.
Lordship, I am
Yes.
appearing for the appellant bank.
Yes.
Your Lordship, this case is the petitioner, who was a writ petitioner, he was absent from his duty from 2002 till his demise till 2016, unauthorized absence. And after his demise, his wife came before this honorable court filing a writ petition seeking pension, Your Lordship. But as per the bank's norms, he is not entitled to pension because his pensionable service has not been completed, which is 20 years.
Single judge has accorded him pension.
Learned single judge has decided that, has held that his termination was not as per process.
We'll hear you on some other day. Let this matter come up. Who appears for the respondent here?
Lordship, on previous 2 occasions, the respondent side was absent. Even today, he is not there.
I said, then we say this. The counsel for the appellant, State Bank of India is present. So there is no appearance on behalf of the respondent. Leave this matter for consideration on after 3 weeks, after 3 weeks before. All right, next.
11-9. Item 22-21.
This goes on some other date.
I'm appearing in 20, item 20.
Okay. So we can see what we do. And 22, 23, 24, who appears?
I'm,
This is a repeal of Muslim marriage
my lord.
of 1935.
My lord.
All these matters will be heard on next day. Some,
Next date means my lord.
he will tell you.
Sir.
Which day? After 3 weeks.
My lord, there are some urgencies there, my lord, the entire community is suffering because there is no provision.
No marriage is going on. Marriage is stalled, my lord.
How is that possible?
Yes, my lord,
The repeal is of the act which
1935.
empowered the Qazis to do that act.
Who will now solemnize marriage? Nobody is there, my lord.
Therefore, the government backed Qazis.
People
should
are
not be
waiting
there.
for marriage, my lord.
Qazis would be there. Who says that marriage is?
All marriage will take place. my
How
lord.
can you, how is that possible?
That's my lord. Private marriage,
Sir, it's
it may
absolutely-
take some private marriage may take place, my lord.
After 2 weeks.
But it will rather encourage those things for child marriage.
All right, after 2 weeks.
Fine.
Yes.
2nd of September.
Give the date.
So hearing it, yeah.
Hearing.
Yes.